case numbers 24CR1298, 24CR1315, and 24CR1316, all of which are case captioned State of Ohio versus Demetrius C. Frett. Present in court is the defendant, who is accompanied by his attorney, Ms. Rachel Smith. We were previously here on all three matters on December 17th, 2024. At that time, the defendant did withdraw his previously entered pleas of not guilty and entered a plea of guilty to count 1, grand theft of a motor vehicle, a felony of the 4th degree in case 1298, guilty of count 1, failure to comply with order or signal of police officer, a felony of the 3rd degree in case 1315, and guilty of count 1, grand theft of a motor vehicle, a felony of the 4th degree in case 1316. This matter was referred to the Lake County Adult Probation Department for a pre-sentence investigation report, as well as for victim impact statements in cases 1298 and 1316. It's the state's understanding that those reports have been completed and the state has had an opportunity to review them. The state is prepared to proceed with sentencing and would move to dismiss the remaining counts of the indictment in case 1298 and 1316. There are 85 days of jail time credit on all three cases, Your Honor. Thank you.
Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. I did have an opportunity to review the PSR before coming to court today, and as well as have discussed my client's history with him at length. We are asking the court to impose a term of community control, potentially with NeoCap or decision points as conditions. Mr. Frett has an extensive criminal history, which I believe the state will place on the record for the court. But some of the things that can't be overlooked with Mr. Frett: he's 21 years old, he's single, he has no kids. At the time of his arrest, he was employed with a narco. He'd been working there for 5 months. He was working full-time, making $18 an hour. He had enrolled himself in school and was actively attending classes in person to earn his GED, because due to life circumstances, he stopped attending school in the 10th grade. Mr. Frett has been respectful, forthcoming, and polite in all of his interactions with counsel. I believe that he has shown the court respect as well and will continue to do so. And if he's placed on probation, we'll show that same respect to his probation officer. Admittedly, the facts of the offenses for which Mr. Frett has pled guilty involve a show of disrespect to authority. Mr. Frett absolutely struggles with impulse control issues and anger management issues. It's the belief of counsel that those issues are reflected largely in his juvenile history, and those things don't happen in a vacuum. What Mr. Frett's juvenile history, which includes domestic violence cases and criminal damaging from 2016 all the way through 2023, after discussing those offenses with Mr. Frett, developed an understanding that those are the result of Mr. Frett essentially having to fight for his life as a 12 and 13-year-old boy when confronted with his mother's string of boyfriends who were routinely abusive. For discipline, Mr. Frett's mother withheld food, and it was through establishing good relationships with the lunch lady at school that he was able to get a double tray at breakfast. Mr. Frett has never had any guidance. His father was incarcerated 4 months before he was born and is still serving 2 30-year sentences for the rape of a child. His mom went to prison for 4 years for felonious assault when Mr. Frett was 9 years old. His siblings ended up in the custody of his aunt at that time, but Mr. Frett was left in foster care. Mr. Frett spent enough time in foster care and in juvenile detention at Cuyahoga County that the juvenile judge eventually told his mom that she had no choice but to take him home because there was nothing more for this system to do with him. There is every element available to the court to justify a prison sentence in this case, and Mr. Frett understands that. But I think that Mr. Frett's youth, his lack of opportunities as a juvenile, the lack of instruction and guidance that he's had, make him an ideal candidate for NeoCap or decision points. And it's my belief that that's what those programs exist for. I think that Mr. Frett has all the potential in the world, and if given the proper tools, is at an early enough point in his life to turn it around. He is here on 3 cases. As the state will point out, these are a continuing course of conduct. It did extend over several months. It also was part of the same series of impulsive, immature choices on Mr. Frett's part. And I don't think that these are distinct acts. Everything is very intertwined, both in this case as well as the open cases that he has in Cuyahoga County. And for those reasons, we would ask the court to impose a term of community control.
Thank you. Mr. Frett, you have the right to address this court before you are sentenced. You can say anything you'd like. Is there anything you want to say at this time?
While I was on probation with Cuyahoga County, to handle my anger issues, I was going to counseling, 3 different types, every week. And I know that I violated probation over there due to the fact that I didn't finish my last 2 meetings, and I violated by catching another case here. I just thought you should know that.
Sorry, I didn't hear the last thing you said.
I just thought I didn't get to tell her, it didn't come up, so I just thought I'd say it at this time.
Anything else you'd like to say? You don't have to. I just want to make sure you've said everything you want to.
I know that I'm here due to my actions in this situation that bring me in front of you today. I'd like you to know that I am sorry for what I've done. It was very stupid on my part. I've had a lot of time to think about it here, coming to and from court and talking to family members that had to put their input into my situation. If anyone that was here that I affected, I would say I apologize to their face, but I really can't do that because they're not here. Being here made me think that this is not the situation I would want to be in again if I was ever to be released back in the general public. It's not something I really do.
What's not something you really do?
Create problems and disturbance. Run-ins with the police is not really my thing.
Got a history of it.
Yeah.
In your pre-sentence report, you said, this is out of character for you. You've never been in trouble before. You've been in trouble since you've been 12 years old. Now, I understand some of the incidents that occurred back then and the circumstances you were in, but to say you've never been in trouble before, it's just not genuine.
Yes. I worded that incorrectly.
Well, yeah.
What I should have said something along different lines. Every time that I was in trouble from when I was 12 years old, it wasn't really that I wanted to be. It was that at the time I really couldn't get through to my mother, speak my mind. She wouldn't really understand, so.
I understand those circumstances back then, but just to say what you said didn't.
It's really hard for me to put certain stuff into words. I can sit in my cell and think about what I want to say, but now that I'm here in front of you, it's like the words just can't come out properly.
All right, thank you. Ms. Smith, anything else you'd like to add?
Just one additional factor, Your Honor, for the court's consideration is that Mr. Frett does not have any documented or self-reported issues with alcohol or any other drugs. He doesn't drink, he doesn't smoke marijuana, and he does not use drugs and did not prior to his incarceration, which is another remarkable factor for someone of his
Thank you. Ms. Himmeline for the State of Ohio.
Thank you, Your Honor. Your Honor, the defendant engaged in a pattern of conduct with these crimes that is indicative of who he really is. In the theft of the motorcycle, which occurred in April, he took advantage of an elderly victim. And then he did it again in June, taking advantage of a teenage victim. He showed up to their homes, both of them who advertise their vehicles for sale on Facebook Marketplace. He used a false name. He tried to befriend these victims in order to let them give him access to the vehicle. And then without their permission, he took them. He had never been a licensed driver, so he had no business taking these vehicles in the first place, even if he had been there to legally purchase them. He also can't title these motor vehicles in his name. In April, when he took the motorcycle from the elderly victim, he then led the Wickliffe police on a high-speed pursuit. They spotted the motorcycle that had just been stolen out of Kirtland on flock camera and gave pursuit. The defendant turned around and gave the middle finger to the officer and then took off at rates of 80 to 90 miles an hour on Euclid Avenue. It's a 25-mile-an-hour zone. It's 2:15 in the afternoon. School's getting out. The pursuit lasted several minutes, several miles. He ran several red lights. He was traveling left of center as he went through intersections, weaving in between moderate traffic. He created a safety risk to himself and all of those people around him. The defendant says in his pre-sentence investigation report that he was scared because he had damaged the motorcycle prior to Wickliffe catching up with him. But then he kept that motorcycle from April until September, never returning it as he alleged he was going to do. He led the Cleveland Heights Police Department on 4 subsequent pursuits on that same motorcycle. They discovered him driving it on September 21st, and they pursued him. But again, it was unsafe for them to do so because he had a passenger, a female passenger, on the back of the motorcycle, and he was driving recklessly and dangerously. On September 26th, twice, the Cleveland Heights police attempted to pull the defendant over, and he led them on pursuits. It wasn't until September 30th, at the last pursuit, that the police were finally able to not only apprehend the defendant, but take possession of the motorcycle. The defendant also has a failure to comply from Cleveland Metro Parks from 2024. So this is his character to run.
That's a pending charge, correct?
That's a pending charge.
Right.
And he was also on probation for disorderly conduct out of Cleveland Heights at the time that this offense occurred. And then he has 4 additional pending charges for the Cleveland Heights failure to comply, as well as receiving stolen property from this motorcycle. The defendant said, as you pointed out, that he didn't have a long record, but that's false. He has an extensive juvenile record. And even if you discount some of that record based on his family circumstances, his adult history just continued. 2022, he gets the disorderly conduct, he has a probation violation, and his probation is extended till October 1st, 2025, and he's out on probation when these crimes were committed. In 2023, he violated a temporary protection order. 2024, he gets the failure to comply from Cleveland Metro Parks that's pending. Then he gets these offenses, steals 2 motor vehicles, leads Wickliffe on a high-speed pursuit, and then leads the Cleveland Heights police on 4 different pursuits. The defendant is a danger and a risk to the public, and he needs to be punished for these offenses. So for those reasons, the state is asking that the court impose a sentence of prison and also restitution orders to the victims in these cases. Thank you.
Thank you. This court has reviewed the pre-sentence report and investigation, the victim impact statements that have been provided. I've considered the facts and circumstances of each of the 3 cases that are before me, the nature of these offenses. I've considered what's been said here in court by the defendant himself, his lawyer, the prosecutor, the recommendations and requests from the parties. All of this is considered in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, For the two theft charges, 24 CR 1316 and 24 CR 1298, the court finds that the victims in each of those cases suffered serious economic harm and, quite frankly, psychological harm when reviewing their victim impact statements. In regards to the case with the motorcycle, the victim was an elderly person at the time. Took advantage of that. His age, how old was he? 80 something?
78
78 years old at the time. Both of those offenses clearly were premeditated as well. Defendant claims that in neither case he intended to take the bike or take the car. That was not his intent. But yet he was dropped off at each of those places. No return ride. So he was leaving somehow. When he went there. He claims that with the bike, he got scared and left, but he was going to fix it and return it. But yet he kept it for 6 months and continued driving it. Never returned it to the victim like he says he was going to do. And he engaged in the same behavior in both of these cases. It'd be very coincidental that in both cases he responds to ads on Facebook Marketplace with fake names, but his intention was really to buy the bike or the vehicles in both of those cases, and he never intended to take them in each case. That defies common sense. It's not credible at all. As for 24 CR 1315, the court finds the defendant have to consider other factors that are set forth in, I think it's 2921.331, dealing with his operation of the vehicle. In that case, the court notes that the defendant committed multiple moving violations, going through red lights, crossing over traffic, operating that vehicle during the middle of the day at 90 miles an hour, and put many people at risk and danger. Those are factors indicating it's more serious. There's nothing involved here that indicates that the conduct in any of these cases is less serious. As for recidivism factors, most of these are present as well. The defendant has an extensive juvenile delinquency history and adult history, despite him claiming that he's got no prior criminal history and never been in trouble before. He was on probation at the time he committed these offenses. He was on bond awaiting trial at the time he committed all three of these offenses in the three cases. He has not responded favorably in the past to previously imposed sanctions, having violated his probation in the past. While in jail, he got involved in a disciplinary incident, threatening an officer, disobeying an officer. There are no factors indicating recidivism is less likely. The defendant's behavior in all three of these cases, it's clearly indicative that he has no respect for any authority or the safety of the public or individuals and their rights. This is not just a one-time incident that he engaged in. This is a course of conduct where he ripped off multiple people and continually defied any authority. Premeditated, well planned out. Prison is certainly consistent with the purposes and principles of sentencing in all three of these cases. In 24 CR 1316 and 24 CR 1298, the court notes that the defendant was on probation at the time he committed the offenses, as well as on bond for other cases at the time. That overrides any presumption for community control. Again, prison's consistent with the purposes and principles of sentencing. There's no way, based on the defendant's conduct here and his complete disrespect for any authority, that the court can find he's amenable to available community control sanctions. Therefore, it'll be the sentence of this court that in 24 CR 1316, defendant be ordered to serve a term in prison of 12 months. He also be ordered to make restitution to Terrence Babick in the amount of $4,906, which represents the victim's economic loss. Court will dismiss count 2. In case 24 CR 1298 is the sentence of the court. Defendant serve a term in prison of 12 months. He's ordered to pay restitution to Gavin Stewart in the amount of $1,170, to Aubrey Stewart in the amount of $2,000, which reflects the value of the car. The balance of that indictment is dismissed as well. In case 24 CR 1315 is the sentence of the court. Defendant serve a term in prison of 12 months. The prison terms imposed in all 3 of these cases are to be served consecutive to each other for an overall prison term in all 3 cases of 3 years in prison. By statute, the prison terms imposed in the 2 theft charges have to run consecutive to the fleeing and eluding. But the court also notes that consecutive sentences in this case are necessary to protect the public from future crime, to punish the offender, and they're not disproportionate to the seriousness of his conduct and the danger he poses to the public, and that he committed 1 or more of these multiple offenses while he was awaiting trial, and in another case, while he was under probation as well. The court further notes that at least 2 of these offenses were committed as a part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed was so great or unusual that no single prison term for any of these offenses committed as a part of any of the courses of conduct adequately reflects the seriousness of his conduct. The court will grant the defendant 85 days of credit in case 24 CR 1315. Since all 3 cases are served consecutive, the credit just goes to one of the cases. There's no credit on the other cases then because he has only served 85 days total. So we'll give the 85 days on 24 CR 1315. The court also finds in 24 CR 1315 that the offense involved here is an offense of violence. And the defendant acted purposely and willfully, and that his conduct created a substantial risk of serious physical harm to others. Therefore, I need to advise you that in this case, upon your release from prison, you will be placed on post-release control. It's mandatory in this case for at least 1 year. It can be up to 3 years. In the other 2 cases, it's discretionary up to the parole authority for up to 2 years. In any of these cases, if you're you're going to be put on post-release control for sure. If you violate any of the conditions of your post-release control, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each separate violation you commit, up to an overall maximum of 50% or half the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control for all these cases. And in all 3 cases, the defendant's ordered to pay the cost incurred in each of those actions. Lastly, in 24 CR 1315, the court is going to suspend the defendant's driver's license or his right to apply for a driver's license for a period of 5 years. I think that covers everything. Ms. Himmelin, is there anything I'm omitting?
No, Your Honor.
Ms. Smith,
I'm sorry, bond.
Bond is released. If there's any bond posted, it'll be released. Ms. Smith, anything else?
Not this time, Your Honor.
All rise. We're here in the matter of the State of Ohio versus Artur Pakis. This is case 24-CR-1250. Mr. Pakis is present in court. He is accompanied by his attorney, Mr. Lucas Trott. Your Honor, the state has engaged in negotiations with the defendant through counsel regarding an investigation conducted by the Lake County Sheriff's Department. And as a result of those negotiations, the state has filed an information charging the defendant with one count of attempted abduction, a felony in the 4th degree, and one count of domestic violence, a misdemeanor in the 1st degree. It's my understanding that Mr. Pakis is prepared to waive his right to have this investigation presented to the grand jury and proceed by way of information, entering a plea of guilty here today. There is no agreement on sentencing. We would ask the court to order a pre-sentence investigation following the plea.
Thank you. Mr. Trott, does that sound accurate?
It is accurate, Your Honor.
And pronounce your last name for me?
It's a Pecos.
Packus?
Yes.
Okay. You know, you guys can be seated during this time. I don't interpret that as any disrespect. It's much easier to be sitting down when we're going through this. It's going to take some time. So, Mr. Packus, you were able to hear what the prosecutor just had to say regarding what she believes your plans are here this morning?
Yes.
She indicated to the court she believes that your desire to waive your right to have this case presented to a grand jury, and I'm going to explain in a moment in more detail what that actually means. Then you're going to plead guilty to the 2 charges and the information, which I will also review with you to make sure you understand those. We will then, the sentencing will be deferred. We're going to refer this for, get some evaluations and reports completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly what you want to do here today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Okay.
All right. Let's get started then. How old are you, sir?
I'm 25 years old.
Are you able to read and write the English language?
Yes, I am.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
Can you repeat that one more time?
What about within the last couple days?
Maybe 1 beer.
Okay. When was that? It wasn't this morning, was it?
No.
All right. I want to make sure, right, as you sit here right now,
Right.
you're of clear mind. You're not under the influence of any drugs or alcohol. What about prescribed medications? Anything?
No.
So whether it's illegal, legal, whatever it is, I just want to make sure you're of clear mind right
Right.
now. You understand your surroundings and appreciate that. No issues with any of that right now?
No.
All right.
That's ours.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the 2 charges that you're going to be pleading guilty to?
Yes, Your Honor.
And at some point you had a chance to look those over?
Yes.
Now, in that information, again, you are charged with 2 counts, and what's alleged here and what you'll be admitting to is on or between September 27th, this is for count 1, on or between September 27th, 2024 and September 28th, 2024 in Painesville Township, Lake County, Ohio, that you did purposely or knowingly with sufficient culpability for the commission of the offense of abduction, that you engaged in conduct, if successful, would constitute or result in the offense of abduction, which constitutes the following conduct: that you did, without privilege to do so, knowingly by force or threat, restrain the liberty of Anastasia Basuic Brinze under circumstances that created a risk of physical harm to the said Anastasia Basuic Brinze, or place her in fear. So that latter language I explained to you is what abduction involves. What you're pleading guilty to is that you engaged in conduct, if successful, would have resulted in that. And the difference between abduction and attempted abduction is abduction is a felony of the 3rd degree. which is more serious, a lot more serious than a felony of the fourth degree, which is what attempted abduction is. You get up to 3 years in prison on the abduction charge with no presumption for probation, whereas a felony of the fourth degree, the maximum sentence is only, I say only, but it's 18 months, it's half of that. So you understand the difference between what you understand what the charge of attempted abduction is?
Yes,
Any-
Your Honor.
Any questions about it?
No.
You discussed this with your lawyer, I'm assuming, beforehand?
Yes.
Okay. The second count alleges honor between September 27th and 28th, 2024, again in Painesville Township, Lake County, Ohio, that you didn't only cause or attempt to cause physical harm to Anastasia Basuic Brinze, a family or household member. That conduct constitutes the offense of domestic violence. It's a misdemeanor of the first degree. Do you understand what you're charged with and pleading guilty to in this case?
Yes, I am, Your Honor.
Any questions about it?
Nope.
Well, then before I can accept your guilty plea to either of these charges, I need to make sure you understand all the rights you are giving up by pleading guilty. And you first of all have the right to have this case presented and considered by a grand jury. Now, the document that I just read to you, those charges are part of what we call an information. An information are criminal charges that are brought by the prosecutor's office without the case having previously been reviewed or considered by a grand jury. Now, what a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating and reviewing evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause is defined as some evidence that would suggest the person probably committed these offenses. Now, everybody in the state of Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision at all, whether someone should be charged or not. And you have that right as well. But you can give up that right if you desire and go forward on the charges brought by the prosecutor in this information, and your attorney has represented that he believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I can go any further on this information, I need to have you recognize and acknowledge that here in open court in writing. And I have in my possession right now a one-page document called a waiver of indictment, which basically sets forth what I've just explained to you about the grand jury and that you want to give up that right. Again, before I can go forward, I need to be assured you understand what this document says and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to review this document with your lawyer. Is that correct?
Yes.
Mr. Trott, is that accurate? Did you review this with your client and read it to him and answer his questions?
I did, Your Honor.
Did he indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Packus?
Yes, Your Honor.
Any questions for me about what it says?
No.
And it also appears here that you signed the document. Did you sign it?
Yes.
And you witnessed that, Mr. Trott?
I did.
Ms. Mulligan, you as well?
I did.
All right, I'll make that document part of the record. At this point, I am going to review with you all the other rights you have that you give up by pleading guilty. And you, first of all, have the right. You have the right to have a trial in this case. And a trial could be to me as a judge, or I listen to all the evidence and I make that decision ultimately whether you're guilty or not guilty of each individual charge. But you also have a constitutional right to have a jury trial. And a jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together one way or the other as to each charge, whether you were guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes.
Now, if we had a trial, you'd have the right to have an attorney represent you at the trial. If you could not afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Now, with her having the burden of proof, what that means is that it's her job, her responsibility, her obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of both of these charges, and that presumption of innocence sticks with you and stays with you until the state, if at all, is ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I talk about this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it means, it's the amount of the evidence, the quality of the evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of these charges that I just read to you beyond any reasonable doubt before you could ever be found guilty of any of those charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least to try to do that if we had a trial, the prosecutor will be calling witnesses to come into court to testify for the state and answer questions from the prosecutor. Now, once those witnesses answer the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. And we call that cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and to answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further could request the court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court, testify for you, and answer your lawyer's questions if they did not want to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision. That's a choice that you and you alone would have to make. Do you understand that?
Yes, Your Honor.
And since that's solely your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify and take the stand on your own behalf if you didn't want to. I can't make you testify. But more importantly, the prosecutor is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further, if you went to trial and you were found guilty of these charges or any charges, you'd have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you are giving up or waiving any right you have to appeal a guilty finding that I will enter if I accept your plea, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all then regarding the rights we've just discussed? These are all the rights you have, all the rights you give up by pleading guilty. Any questions?
I do not have.
Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes, I am.
Do you understand a guilty plea will be a complete admission of guilt? That means you'll be admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as potential sentences go, you're pleading guilty in count 1, the attempted abduction, to a felony of the 4th degree. This offense carries with it a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Now, count 2, the domestic violence charge, is a misdemeanor of the 1st degree. This offense is punishable by a term, by serving a term of local incarceration in the Lake County Jail of up to possibly 180 days. Do you understand that?
Yes, Your Honor.
Now, in this case, you're pleading guilty to 1 felony and 1 misdemeanor. If I were to impose a prison sentence on the felony charge in count 1, any jail time sentenced on the domestic violence charge by law has to be served concurrent with a prison term. Concurrent means you serve it at the same time. Serve the sentences together. I am not allowed to sentence you to a prison term on the felony charge and then run the jail sentence consecutive to the prison term. Consecutive means one after the other. So I can't say serve the prison sentence and then when you're done, serve the jail sentence. I'm not allowed to do that. They have to be served together if I send you to prison on the felony charge. You understand that?
Yes, Your Honor.
So in this case, the maximum sentence that you face with both charges is 18 months in prison. You understand that?
Yes, Your Honor.
Now, are you currently on probation or parole or any type of supervision to any other courts or agencies?
No.
Do you have any other criminal charges pending against you anywhere?
No.
If a prison sentence is imposed in this case, upon your release from prison, you could be placed in what we call post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this case, it could be up to 2 years. You understand that?
Yes, Your Honor.
And if you were on post-release control and you were violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case. On the felony charge, you'd be fined up to $5,000. On the misdemeanor domestic violence charge, you'd be fined up to $1,000. So altogether, there's a maximum fine of $6,000. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay court costs, reimburse the county for any costs of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes.
You could also be ordered to pay restitution to the victim for any economic loss any victim may have suffered as a result of the criminal conduct involved. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence you face. I did use the word possible because prison is not mandatory with any of these charges. You are eligible for probation or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Now, do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information presented to the court, then I'll make the decision that ultimately I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on probation, it could be for up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules and conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of your probation. So even if you were to get probation or community control, it doesn't automatically mean there's no jail or incarceration. It doesn't mean there is. But you could be incarcerated locally in the jail for up to 6 months as a condition of your probation. You understand that?
Yes, Your Honor.
Further, if you are in community control sanctions to this court at any point and you ever violate any of the conditions of your supervision, we would have a hearing here in court to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, again, it could be ultimately up to 18 months in prison. You understand that?
Yes, Your Honor.
Lastly, when we do come back here for the sentencing hearing, you're going to have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He's allowed to recommend a sentence to the court. The prosecutor can also recommend a sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. And I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all regarding the potential penalties you face by pleading guilty here?
No.
You understand all the possible consequences and what can occur at sentencing?
Yes, I am.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this matter with your lawyer and have him go over everything with you, the reports, answer your questions?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Has he, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, do you have any questions for me then at this time regarding anything we've just talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to speak with your lawyer before we go forward with the actual plea of guilty?
No.
All right, then what's going to happen at this point? The prosecutor here is going to explain for me what she believes the evidence would show at a trial if we did have a trial. I want you to listen to what she says because then I will have some follow-up questions for you, all right?
Okay. Yes.
Ms. Mulligan?
Your Honor, the state would be prepared to show that on September 27th, 2024, the victim Anastasia went over to the defendant's residence in Paynesville Township, Lake County, Ohio. The defendant and victim had lived together for approximately 2 years prior, but had broken up just 2 months before this incident. The victim decided to leave this residence in Paynesville Township because there was an argument, and during the course of the argument, the defendant hit the victim, elbowed her in the mouth, causing her injury. She tried to leave to get out of the house. She managed to get out of the house. She would describe that the defendant dragged her back into the house. She once again got out of the house and into her car, and the defendant continued to try to prevent her from leaving by jumping on her car, causing damage to her car. And the victim, under these circumstances, was in fear.
Thank you. So, Mr. Packus, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we did have a trial in this case?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she just presented them? Are they true? Did you do as she said?
Yes, that's true.
Very well, then, regarding count 1, charging with attempted abduction, a felony of the 4th degree, what is your plea to that count?
Yes, guilty, yes.
Okay. Regarding count 2, charging with domestic violence, a misdemeanor of the 1st degree, what is your plea at this time to that charge?
Guilty.
All right, I have in my possession at this time another document. This is a 4-page document which explains everything I've just reviewed with you. The rights you're giving up, penalties you faced, what you're pleading guilty to, consequences. Before I can accept your plea, I need to make sure you understand everything in that document and that you signed it here in court. Now, my understanding, again, is before I came out here, you had a chance to go over that 4-page document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Trotter, again, is that accurate? Did you review this with your client and read it to him and answer his questions?
I did, Your Honor.
Did he, again, indicate an understanding of it to you when you did that?
He did.
Is that correct, Mr. Packus?
Yes, Your Honor.
Now, it also appears that you signed this document. Did you, in fact, sign that document?
Yes.
And you witnessed that, Mr. Trott?
I did.
And Ms. Mulligan?
I did.
Very well, then. At this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of all those rights. Court also finds the defendant does understand the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, finding the defendant guilty of count 1, attempted abduction, a felony of the 4th degree, violation of 2923.02 and 2905.02a, as well as count 2, domestic violence, a misdemeanor of the 1st degree, violation of 2919.25a. I will defer sentencing, order a pre-sentence report and investigation, victim impact statement. Any issues with drugs or alcohol you want to explore with a separate report for that, Mr. Trott?
Your Honor, I think at this juncture we are going to get him assessed. I think any resolution in this case might resolve with some alcohol
All
counseling.
right, then I'm going to order a drug and alcohol evaluation as well. I'll continue bond. I have it at $50,000, cash surety 10% with an order that I have no contact with the victims and GPS monitoring.
That is correct. There was some issue that the defendant has a job that causes him to work out of the state for day trips, and the state has no opposition to that. That wasn't really clarified at the local level, but provided that probation is advised of his work schedule, and the only times he leaves the state is not overnight, but just for work purposes, the state is satisfied with the condition.
Well, it doesn't appear that's happened at all.
I have a note that Craig Berry was aware of something like that.
Your Honor, if I may.
Sure.
We did have this discussion in municipal court on the record. Judge indicated that he was okay to travel out of state. I don't know if that was ever formalized on a filing, but he does travel to, as far as Michigan, Illinois, Indiana, and Pennsylvania for work. He's a commercial driver for Row Express Limited, which is located in Middleburg Heights. That's his primary and only source of income. We would ask that he be permitted to continue doing that.
Middleburg Heights, where's that? Cuyahoga
It's in
County, right?
Cuyahoga County,
We should probably put that in here at least, but.
He travels to Cuyahoga County to pick up his vehicle, I believe, on a daily basis, and then goes to wherever he's assigned.
How often do you travel out of state, you think?
How often? Monday through Friday.
Usually throughout the week?
Yeah, like I wake up 5 in the morning and just come back home around like 6, 7, 8, depends how traffic is.
Oh, so it's like a day trip, or day trips
Yeah.
you take?
Like it's unlikely I can be like somewhere in a row sleeping in the truck because I always have to come back.
You have the GPS monitor on?
Yes, Your Honor. I've been having.
Your Honor, if it's okay, I would also like to be heard on the GPS monitor briefly. I had a quick conversation with Ms. Mulligan this morning. Mr. Packus at this point indicates that it's becoming somewhat of a financial hardship for him. At this point, I don't expect Ms. Mulligan to have a position, given the fact that she's standing in and has not had a chance, I assume, to talk to the victim and get her stance. In that same realm, I don't expect the court to have any any intent to grant our request at this juncture until those conversations can be had. But we would respectfully ask the court to consider removing that GPS just to relieve him of that financial hardship. He has been under supervision since his arrest, since he got out. He is fully cognizant of the fact that he needs to comply with the stay-away order, irrespective of whether or not he has his GPS monitor on. At this point, he has done so, and his newest development of having accepted responsibility at the first possible juncture would, I think, indicate that he's amenable to that.
Yeah, I get that, but I mean, you're asking me, one, to let him
I-
travel over the United States, and then two, to take off the monitoring device.
I
And
understand.
I'm not doing that at this point.
Okay.
If you want to file something at some future point here, I'll consider that, and but I'm not going to do that today.
Understood.
I will allow him, however, to travel. So do you spend the night ever?
Unlikely. It can be like only like when I get broke down, for example. It happened like maybe months or twice ago, like twice that.
Aren't you only allowed to? I don't know. Aren't you only allowed to drive for a certain amount of hours before you have to?
Yeah, it's a logbook. Like it's a kind of like the thing that we put in. They only allows us to drive for 13 hours, and 1 hour to break. So like 14 hours total.
You drive 13 hours, and how long do you have to rest?
8, 9. I mean, 8 hours. I have to sleep minimum. So.
Okay. All right. Well, I'll allow him to travel out of state for purposes of work Monday through Friday.
Thank you, Your Honor.
And then if you want me to consider that file something separate.
Absolutely. Thank you.
So, Mr. Packus, I'm sorry. What's going to happen now, I'm continuing your bond. It's the same as it was. There's nothing that's changed. You need to comply with the conditions of your bond, which involve not having contact with the victim, and also you're not allowed to use any drugs while you're on bond. You have to submit urine screens if requested. They have to be negative. A positive screen would result in your bond being revoked and a warrant being issued for your arrest. And it doesn't matter if you're working. You're not going to be able to come back here and say, well, I got this job and I need to work. You make sure you think about that. I'm not saying there is issues. I don't know if there are or not. But make sure you think about that before, if you decide to ingest anything, because you're going to end up in jail. And coming back to me with an excuse about working or anything else is not going to matter. You understand that?
Yes, Your Honor.
Okay. Same with any other condition of bond. Now, the whole point of this pre-sentence report and the evaluations I'm ordering is so that I can learn more about you before sentencing. The way the probation department will get the information they need to prepare this report is they're going to conduct some interviews with you. They'll administer some tests. It's very important that when you meet with them, that you're open and honest with them, because they check and verify everything you tell them. And if they learn you're misleading them in any way, they're going to let me know that, and I would certainly consider that at sentencing. You understand that?
Yes, Your Honor.
Also, this report that I'm ordered, both the reports, especially the pre-sentence report, that must be completed if I'm allowed to consider probation as an option. Without a pre-sentence report, the law does not allow me to consider probation at the time of sentencing. In order for that report to be completed, that interview with you has to take place. So it's important that you show up at the probation department when you schedule that with them on time and be there so that they can conduct that interview. Without the interview, they can't do a report. Without a report, the law does not allow me to consider probation. You understand that?
Yes, Your Honor.
All right. So what's going to happen now, you're going to leave here now, you're going to go over to the probation department. Do you know where that is or not, Mr. Trott?
I don't, Your Honor.
It's in the, I don't know where, did you park? It's parked behind the courthouse. Not parked. Are you parked behind the courthouse?
We're in front.
Oh, you're in the
Yeah.
front? So it's on the other side, which is that way. It's the Lake County Jail. It's the Sheriff's Department. It's on the 3rd floor. When you walk in, you go to the right. There's elevators. You go up to the 3rd floor. They're going to be expecting you, and you're just going to be going there to fill out some paperwork and get your dates to come back for the interviews and the tests. So make sure you let them know what works for you with your schedule, but you need to be there whenever you schedule this with them, all right?
Mm-hmm. Yes, Your Honor.
All right, I think that covers everything. Ms. Mulligan, anything else?
Nothing further from the state.
Mr. Trott?
Nothing, Your Honor. Thank you.
All right, thank you all. All right, we are hearing case 24 CR 1320. This case is captioned State of Ohio versus Alexander Sinclair. State has filed previously a motion to deny bail pursuant to revised code section 2937.222. Court initially granted that motion without a hearing. Subsequent to that, a pretrial was held between by the court and the attorneys involved. At that hearing, defense counsel raised the issue of this denial of bond without a hearing. The court had granted initially, relying on the hearing that was conducted, or at least the docket indicates a hearing was conducted in the Painesville Municipal Court. During that pretrial, was relayed to the court, this court, that that hearing wasn't really the type of hearing that was contemplated by 2937.222. Defense counsel filed a motion to reconsider the denial of bail without a hearing. Court granted it, scheduled a hearing, and that's what we're here for at this time. Defendant is here in court. You're Mr. Sinclair, Alexander Sinclair.
Yes, Your Honor.
He is here in court. He's with his counsel, Rachel Smith. State of Ohio is represented by Assistant Prosecuting Attorney Adam Downing. So, Mr. Downing, are you prepared to proceed at this point?
Yes, Your Honor.
Obviously, we're only dealing with the one case. The other case, the court, there's a bond that was set in the other case, so that one's not an issue here. It's just 24 CR 1320. So you may call your first witness.
Thank
Or do
you,
you want to
Your
make any statements first? I'll let you do that.
I will waive opening, but I would just move for the record, on page 3 of my brief, under law and argument, the first sentence that references criminal rule of procedure 46A, obviously that has been repealed for some time now, and so that's an error on the state's behalf. I just moved to strike that first sentence from law and argument.
That'll be stricken.
State calls Detective Dominic Wren.
Good afternoon. Please raise your right.
R-E-N.
And where are you currently employed?
Lake County Sheriff's Office,
And what is your position there?
detective,
How long have you been a detective with Lake County?
6 years.
And what was your position before that?
It's a patrol deputy,
For how long?
4 years.
And so you've been a certified peace officer in the state of Ohio for 10 years?
Yes.
Where did you do your training to obtain that certification?
Cleveland Heights Police Academy.
And is there a shift that you normally work as a detective with Lake County?
It's not typically 9 to 5, 9 a.m. to 5 p.m. Monday through Friday.
Okay. I want to take you back to October 31st of last year, 2024. That morning, were you on duty that day?
I was in a training class, but yes.
Okay. Where was that training class?
The Lake County training facility, which is on Blaze Nemeth Road in Painesville Township.
Okay. In that morning, did you have to leave that class?
I did.
And approximately what time was that?
About 9, 10 in the morning.
Okay. What happened at about 9, 10 in the morning?
Lake County received a 911 call from Lisa Chorba, and there was reports of shots fired at Riverview Elementary. So I didn't actually hear the radio call. Somebody in the office did and notified some of us who were in the training class, and then I left the training facility and responded to Riverview Elementary.
Okay. And upon arriving on scene, you then, and subsequently since then, have become more or less the main case agent on this case. Is
Yes.
that right? Okay. And based on your investigation, were you able to learn who was involved in the incident that we're going to be discussing today?
Yes.
And who are those individuals?
The defendant, Alexander Sinclair, and the two victims, Lisa Chorba and John Aller-Heiligen.
Okay.
What was the last name of the other? John what?
Aller-Heiligen?
If the court would permit, I can spell it.
Good.
Allerheiligan.
Okay.
Can you tell me about the relationship between these individuals and anybody else involved with them?
Yes. So Alexander Sinclair and Lisa are married. They've been married at the time for 4 years. John is friends with Lisa, and Lisa and Alexander have one biological daughter. She's a 2-year-old named Charlie.
Okay.
A 2-year-old daughter named Charlie.
And do they live together?
They do.
At the time that this happened, did they live together?
Yes, they do.
In which city?
Madison, Ohio.
Are there any other children involved with this family that you're made aware of?
Yes.
Who is that?
So Lisa has 2 other children. She has a 5-year-old named Sebastian Chorba, and then she also has a 10-year-old son, Carson McKinney.
And Carson and Sebastian, they are not the defendant's biological children, is that right?
They are not.
They just share that one child, Charlie.
Correct.
And did you learn where the defendant was employed, if anywhere?
Yes. He was employed by the Cleveland Police Department.
Okay. In what role?
He was a sergeant in the 5th District.
So I want to go through chronologically what you now believe occurred that day, not what happened chronologically in your investigation. Does that make sense?
Yes.
Okay. So take me back to the beginning of that day at the first relevant time and tell me what you were able to learn.
So we learned that Lisa, she had picked up her son, Carson, that morning from his father's house. She was employed at the time at Child Time Daycare, which is in Painesville Township. She arrived at Child Time at about 8:30 in the morning with Carson after picking him up from his father's house. Shortly before 9 o'clock in the morning, John arrived at Child Time. John and Lisa had made plans to go out to breakfast after taking Carson to school. Just after 9 o'clock in the morning, the defendant arrived at Child Time, and then at that point he would confront Lisa, John, and Carson as they were in Lisa's vehicle getting ready to leave.
Okay. And what vehicle did Lisa drive to Child Time that day?
She had a Buick Enclave.
Okay. And the defendant, you said, also arrived at Child Time
Yes, he did.
in a separate vehicle?
Yes, he did.
What vehicle was that?
It was a Hyundai Santa Fe.
Okay. You mentioned that Lisa and John were going to leave Child Time to take Carson to school. Is that right?
Correct.
Where did Carson attend school?
Riverview Elementary.
And that is the same place the 911 calls came from.
Correct.
Where is Riverview Elementary in relation to Child Time Daycare?
Riverview Elementary is at 845 Madison Avenue. It's about a mile and a half west of Child Time Daycare.
Both in Painesville Township?
Yes, they are.
What would be the easiest way to get from Child Time to Riverview Elementary?
There's an entrance and an exit from Child Time directly onto Madison Avenue. If you make a left-hand turn and begin heading west on Madison Avenue, it's a direct line to Riverview Elementary.
And approximately how long would it take to get between those two places?
A couple minutes.
Now, you had earlier mentioned that Lisa and John were friends, is that right?
Yes.
You did learn, though, that they had something of a different than a friend relationship, is that right?
It was, yes, we learned they did have some type of a romantic relationship.
Okay. And so tell me what happens. You mentioned the defendant arrives at Child Time, and tell me what you learned about after he arrived at Child Time Daycare.
So after he arrived at Child Time, shortly after, John, Lisa, and Carson, they exit the front door, which is on like an upper parking level. There's 2 levels to the daycare. There's the upper and the lower. So they exit the front door on the upper level. They get into Lisa's Buick Enclave. Lisa's driving. John's in the front passenger seat, and then Carson is in the back seat. As they get in the car and begin to back away, the defendant, who he had arrived from Madison Avenue and then came through the lower level up to the upper portion of it.
How do you know that?
From surveillance video.
Okay.
From what?
Surveillance video? Yes.
From Child Time?
Yes.
Okay.
So he arrives, he parks his car, and then at some point, this part's not captured on video, but at some point he exits his car and he goes to the front passenger seat and begins to punch the front passenger side window of Lisa's Enclave.
And how did you learn that information?
From interviews with Lisa and John.
Okay. Tell me what happens next.
As the defendant begins to punch the window, there's some conversation in the car between Lisa and John. They, trying to figure out what they should do. They decide that they need to get Carson to school, so Lisa just begins to drive away. At this point, as they're driving away, we pick them back up on video. Lisa leaves through the lower level, turns onto Madison Avenue. The defendant gets back in his car, and we know from video he actually starts to drive away with the driver's side door still open, as he's sort of like he's got like one leg out of the car. He closes the door, and then he leaves through the lower level onto Madison Avenue, and then follows Lisa's car.
And based on your interviews with John and Lisa, were they expecting the defendant to be there at Child Time?
They were not.
Was there any reason for the defendant to be there that you were made aware of?
None that I was made aware of.
He wasn't dropping anybody off there that day?
No.
Was there anybody in the car with the defendant when he went to Child Time?
There was, yes.
And who was that?
It was their 2-year-old daughter, Charlie.
And so what happens next after the two vehicles leave child time?
So Lisa's vehicle begins to drive west towards Riverview Elementary. The defendant follows behind in his vehicle. Lisa arrives at Riverview Elementary. She pulls into the parent drop-off section where, if you're dropping your kid off in your own car, drops Carson off at the front door.
And let me back up a little bit. Can you describe Madison Avenue? What is it like? What is the speed limit? What is that area like?
Yes, it's a 2-lane east-west road, so there's 1 lane going west, 1 lane going east. It's a double yellow line. The portion they were driving on was a double yellow, so it was a no passing zone, and the speed limit is 35 miles per hour.
And what type of area is that in?
There's residential houses on both sides, and then there are portions of it where there are businesses on both sides. So it's a combination of residential and business.
And did the defendant follow Lisa's vehicle out of child time to Riverview?
He did.
And were you able to speak with any witnesses that were on Madison Avenue that observed anything relevant this time?
Yes.
And what did you learn based on speaking with those witnesses on Madison Avenue?
So the one witness, she was backing out of her driveway at 1240 Madison Avenue. As she was backing out, she noticed a silver SUV, which she described as driving between 80 and 90 miles per hour, traveling west. That car passed her. She was able to back out of her driveway, and then she continued west because she had a child actually to drop off at Riverview as well. And then she described the defendant's vehicle as weaving in and out of traffic and driving at a high rate of speed.
Now you mentioned Lisa then does arrive at Riverview to drop off Carson, is that right?
Correct.
And the defendant also enters that lot?
Yes.
Okay. I want to put up State's Exhibit 1 here. Computer.
Is that it?
Yes, that was it.
Oh, okay. Oh, that's your computer, huh?
Yes.
That didn't look like an exhibit, all right.
Okay. I'm going to give you the pointer here, Detective. And we're looking at an overview of Riverview that was taken by a drone and then interlaid into a map, is that right?
Yes.
Okay, and can you just orient us as to what we're looking at here and anything relevant that we should know about?
Yes. So this is the school building right here. The bottom of the screen where it's like the black line right there, that would be Madison Avenue going east-west. This
The very
entrance,
bottom of the computer screen?
yeah, the bottom of the computer screen would be Madison Avenue.
Sort of off the photo though.
Yes.
Okay, gotcha.
This entrance, so there's 2 entrances designated for student drop-off. This first, the easternmost entrance, this is where the school buses would go. So the school buses come in here, they go around here, and then they exit through the same way that they came in. The second entrance to the west is where parents drop off their children if they're driving their own car. So they would come in through here, they make this loop right here, they come around, and then they exit through that same entrance.
Okay.
So what's in between the 2 parking lots? There's like a green oval.
Yeah, so this
like
is
a racetrack.
parking.
To the right there.
Right here?
Yeah,
This
that.
is like a giant divider between the 2 sections. There's a little opening right here that you can get through, but this is just like an island, basically.
Is it a building or anything, or just?
It's just grass.
Oh,
Grass and
grass.
sidewalk.
Okay.
Grass, and it looks like a sidewalk, right?
Yeah, correct.
Okay.
Gotcha. Right.
So the bus drop-off and the car drop-offs are happening simultaneously but separate from each other?
Correct.
Okay. What time does Riverview Elementary start accepting kids for drop-off, and what time do they start approximately?
Speaking with the staff, they typically start allowing, the buses will typically arrive about 8:50, and they start allowing parents to drop off students typically around the same time, about 8:50, once the SSO and some of the staff comes outside to meet the kids.
Okay. South of the 2 parking lots, there's another big green space there that looks like it butts up to Madison Avenue. Yeah.
Right.
What is that area?
I want to say there's like a small pond there maybe, but it's like it's all grass and just there's nothing really there. There's a marquee for the front of the school, and that's about it.
Okay. From Madison Avenue north to the building of the school, that's all school property?
Yes.
Okay. You mentioned that there's an SSO for the school. What is that, and who is that?
So he's employed by the sheriff's office. He's a deputy, and we have a deputy assigned in each of the schools in the Riverside School District. So for Riverview Elementary, it's Deputy Al Ward, and he's assigned full-time to Riverview Elementary, and he's there during all school hours.
And during this drop-off time, what types of things would he be engaged in on a normal day-to-day basis?
He's typically out. Sorry, I mean.
I don't know what just happened there.
I don't know what you said
There
either.
you go.
He's typically outside. He'll greet the students, and he's sort of him along with some of the other staff make sure everything flows smoothly, and also provides additional security for what may be going on.
Okay. So now let's back up to when you mentioned that Lisa and the defendant arrived at Riverview. Now that we're looking at State's Exhibit 1, can you describe what you were able to learn as to what happened here?
Yes. So that same witness, her name's Brianne, the one that was backing out of 1240 Madison Avenue. There we go. So Lisa is able to pull to the front of the school. She drops Carson off, so she's continuing through this loop here. According to the witnesses, the defendant parked his car somewhere in this area over here.
Like the southern edge of that, the left side parking lot?
Correct.
Okay.
Somewhere in that area, he parked his car. Brianne says she saw the defendant exit his car, and then he goes around his car into the front passenger side of his car and starts digging around in the front passenger seat. She wasn't really sure what he was doing at that point, but after Lisa drops Carson off, she starts driving here, like south, back towards the parking lot. At that point, the defendant drives his car, and right here, there's a stop sign, which applies to cars coming south. And at that point, the defendant drives his car across that area and strikes the Lisa's car.
And that's actually what we're looking at in State's Exhibit 1, is that right?
Correct.
This was taken by an overhead drone?
Correct.
Okay, so
Which car is which, just for the record?
Yes, that was going to be our question.
This is a Buick Enclave. That's the one that was driven by Lisa with John.
That's the grayish, silverish car, I guess?
Yeah, sure.
Darker gray
Darker
car, I guess?
car?
Yep. And then this lighter colored car right here is the Hyundai Santa Fe driven by the defendant.
Okay.
And so the defendant drove through at least a portion of that grassy area to end up where he did, right?
Correct.
Okay. Was there damage to the cars?
Yes,
So
there
the
was.
front of his vehicle is facing Madison Avenue, right?
Yes.
Okay, gotcha.
Yes, there was. Damage.
Okay. Let's go to Exhibit 2A here. So what are we looking at in Exhibit 2A?
This is another photo taken by a drone, just a little closer view of. So again, this is going to be the defendant's car, and this will be the victim's car here.
And 2B?
Just a different angle, again, from the same drone. To the left here, that's going to be the defendant's car. To the right is the victim's car.
And lastly, 2C.
And this was these photos were taken by Detective Smith from Painesville Police Department. See, this is the damage to the defendant's car here, and then this is the victim's car here, to the left.
Okay, so after the, let's call it just the accident, after this contact between these two cars are made, what happens next based on your investigation?
So after this collision, the defendant, who was in the silver car to the right, gets out of his vehicle and he approaches the front passenger window of the Enclave.
Okay, and what happens when he approaches the front passenger window?
He's holding a gun and he continues to punch. So I don't think I mentioned previously, at child time, as he's punching this window, it doesn't shatter, but it's like spider web fractures initially, so he doesn't actually break through the window. When he gets to the front passenger side window here, he's able to break the window, and I don't know if he pulls it down or somehow he's able to remove the window from where it's at, and it's just hanging like this. And then he reaches in and begins to grab John using his hands.
Okay. Prior to reaching the passenger side window, did anybody see the defendant with a gun?
Yes, there were witnesses, and then Lisa as well as John saw him with the gun.
Okay. And then describe what we're looking at here in Exhibit 3. You mentioned the passenger side window, but now that we're looking at this exhibit, what do we see here?
Yeah, so the spider web fractures that you'll see kind of in the center where there's like a red dot. Sorry. Wrong button. I apologize. So right here, this is some of the spider webbing that would have occurred initially, and then this is the window, and it's kind of just like in the frame of the window. So he was able to pull the window down to its current state, and then he's actually standing outside of the vehicle and reaches in with his arms and grabs John.
As the door is shut.
With the car doors shut, correct.
We also see some additional red up near the top right of the window.
Yes.
You see that? And what is that?
That blood.
So based on discussions in your investigation, interviews with individuals inside the car and witnesses and your investigation, what happens next?
So the defendant begins a physical altercation with John. He reaches into the car. He has him by the neck and by the head with one hand, I should say, and then in his other hand, he's got a gun, and he is threatening. He's threatening John, threatening to kill him. He's asking questions of Lisa, saying things like, "Do you love him?" Asking what's going on here, things of that nature. And then at some point during that altercation, the defendant discharges the firearm.
Okay. Are there any 911 calls made? Well, you mentioned earlier there was 911 calls made, but when does the first 911 call occur?
So the first 911 phone call is actually made after the defendant discharges the firearm.
Okay. And who makes that call?
Lisa Chorba.
Okay. And where is she when she makes that call?
She's still in the car, I believe.
Okay. And did you later learn that during the course of her making that phone call, that she was able to do something else, whether intentionally or by accident?
Yes.
And what is that?
So as she was taking out her cell phone to make the phone call, again, whether it was an accident or on purpose, she was able to capture 2 photographs of the incident, specifically of the defendant and John.
Okay. So I want to show you Exhibit 4A and B. And what are we looking at here?
So this is, he's broken the window at this point. This is the defendant. He's reaching in. This is where he's attacking John.
John's the white male in the neon shirt?
Correct.
Okay.
And then again, these pictures were taken by Lisa, who's in the front driver's seat.
And 4B.
This is just the second photograph that Lisa was able to take.
Okay. And do we see the gun in this photograph?
I don't believe so. No. No, but it looks like he's got one hand against the outside of the car, out of view.
Did anybody else on scene observe this interaction at the time other than those who went inside the car?
There was the witness that was directly behind them at the stop sign.
Okay, let's go to Exhibit 5 here. What are we looking at in Exhibit 5?
So this is the same witness that we talked about, Brianne, who was backing out of her driveway. So she had saw everything that led up to this, the erratic driving, the defendant going, to the passenger side of his car in the parking lot. So she at some point pulled out her phone just to record the incident, not really knowing what was going on. And she was able to take one photograph, which is what we see here, and then she also was able to take a short video.
And what do we see in this photograph?
This is the defendant. He's leaning inside of the victim's car. Or he's standing outside the car leaning into the front passenger seat.
Now you mentioned there was a gunshot that was fired.
Correct.
Okay. Let's go through States Exhibit 6A through H, and we'll go through these quickly, but just point out what we're looking at here in these photographs.
This is the where the bullet exited the front windshield of the Enclave.
Just one bullet was fired?
Correct.
And 6B?
So the crime lab just measuring the angle that the bullet would have been traveling, estimated.
Okay. So based on the photograph here, it appears the bullet traveled from kind of like a diagonal from the passenger side window. Is that right?
From the inside of the vehicle to the outside,
Yes.
correct.
And 6C?
Just a different view, but again, yeah, the bullet was discharged inside the vehicle and it exited the front windshield in like a southeastern direction, pretty much.
6D?
This is a view from inside the car. You kind of can see the exit there, and then the bullet, we believe, based on a defect on the defendant's car as well as some testing, that it struck the top B pillar of the defendant's car as it exited.
Were you or the crime lab able to recover a projectile?
No.
Do you have any idea where it went? Or?
No.
6E?
So this is the very top of the defendant's vehicle, and again, you'll see right underneath that little ruler marker there, just above where the laser's at, there's a small defect, and that later it tested positive for some copper, the presence of copper. So we believe that the bullet exited the Enclave, and then it just skipped off the top of the defendant's Santa Fe.
6F?
And this is just a close-up of that same thing, the defect's right just above the pointer there.
6G?
So the inside of this is the front passenger seat of the Enclave. So on the, oops, sorry. There we go. This is just some glass, broken glass, and then right here on the chair, this is the shell casing that we recovered.
And 6H.
And just a close-up, and that's the recovered shell casing from inside the Santa Fe. I'm sorry, the Enclave.
And you later learned that this shell casing was fired from a Glock 26 firearm, which was recovered on scene. Is that right?
Correct.
And that's a semi-automatic firearm.
Yes, it is.
And what does the presence of the spent cartridge casing inside the car tell you when a gun like this is fired?
So when we first saw this, because when we first showed up, we saw the hole in the windshield. We didn't know whether the round was fired from outside or inside, but with the shell casing being there, we thought it was pretty likely that the gun was actually discharged inside the vehicle.
Okay. And did you talk to John and Lisa about the gunshot specifically?
Yes.
And what did they describe about the gunshot and why they believe it happened?
So as the defendant is assaulting John with one hand, he's got his gun in the other hand, and at some point he has the gun pointed at John towards them, and then he points it away from them towards the windshield, and that's when the round is discharged.
Okay. So they don't believe it was a result of a struggle where they were able to push the defendant's hand away and it fired off during that course, right?
No.
Okay. They believed it was more like I would say like a warning shot is what they described it as.
From the interviews we did, yes, that's what it sounds like.
Okay. When this round was discharged, where was Charlie Sinclair, who you earlier testified was in the defendant's car?
Correct. Charlie was in there's the child safety seat on the rear driver's side of that car. That's where Charlie was seated at.
Okay, the same car the bullet struck on its way out.
Correct.
Wait, so that's the defendant's car?
Yes, it is.
And then you can see Lisa's car where the gunshot occurred in the background here through the rear passenger window. Is that right?
Yeah. So
Say that again?
You can observe Lisa's car through the rear
Oh, I see. That's the
passenger
hood of
window
it? You're seeing the hood?
Yeah, the hood's right here, and then the windshield's right here, and the bullet came out
Gotcha.
just above that, and then what will be the B pillar right here. The bullet struck just.
How
above
old's
it.
Charlie? Is she two?
She's 2 years old. So this is where the bullet struck just above,
Right.
up here on the outside.
And then 7B, what's significant about 7B?
So that's Charlie, and this is the defendant's car, and then this is the victim's car here, and then this is one of the victims, Lisa, standing right here holding Charlie.
And you mentioned earlier that this witness, Breanne Harvey, took a photograph of the gunshot. Is that right?
Took a video.
Or a video of the gunshot. I'm sorry.
Correct. Yes.
Okay. And were you able to collect that video?
Yes.
All right. I want to go to State's Exhibit 8.
So that was the mother holding the child? That was
Yeah.
Lisa?
Yes. So actually, yeah. So when I arrived,
Lisa was not didn't have that child initially. The child was with the defendant.
so when I got there, which was at 9:14, so a couple minutes after this happened, I started talking to Lisa, and at some point during our conversation, she actually we were talking sort of in this area over here. She walked around. We were over here. She walked around to the defendant's car, and she noticed that Charlie was in the back seat and pulled her out. So that nobody actually really knew Charlie was in the car until probably a couple minutes after.
So she didn't have Charlie initially?
She did not.
Okay, gotcha. All right, go ahead, Mr. Dunn.
Right. You learned that when she left earlier that day from her house where she shares with the defendant, she left alone, and the defendant was at home with Charlie.
Yes.
All right. Now I want to go to Exhibit 8, and I started playing it. I didn't hear sound, so this video does have sound on it.
Yeah. There's.
All right. I'm going to play this again, but what did we just see, and what are we looking for?
So this was the video recorded by Breanne Harvey just after she took the picture, and this is going to be when the firearm's discharged by the defendant as he's leaning inside the vehicle.
All right. And about less than a second in, we see a plume of smoke come out from the front of Lisa's car. You see that?
Yes.
And what is that?
That's just going to be some of the glass, some of the shards from the glass, and as it's exiting the windshield.
Okay.
Oh. Okay, what happens after the gunshot?
So after that, there's the school safety officer, Deputy Ward. He hears the gunshot. Several of the other staff members, because there's a lot of staff that's going to be down towards kind of by the road, helping, directing traffic and things like that up by the school. They hear the gunshot. They overhear the disturbance prior to that, and then right after that, that's when Lisa makes the first 911 call, and the school safety officer begins to run over towards where this occurred.
Okay. So let's go to the 911 call, starting here with State's Exhibit 9A.
Please don't tell me. No, you wouldn't cheat with my fucking wife, right?
911. I'm trying to help you. Where are you? Are you at 835 Madison?
Yes, please.
Are you at 835?
Get the fuck here, seriously.
Is anyone hurt? Is anyone hurt? Ma'am, I need you to talk to me. Is anyone injured?
I fucking can't calm down. What the fuck don't you understand? Riverview Elementary School on Madison Avenue.
Okay, well, I did not hear that, so you have to talk to me. What happened? Is there someone in the
Seriously.
school that's shooting? I
You
need to
just
know.
shot my husband just shot my car.
Your husband just shot into your car?
Like, oh my god, you're fucking
We obviously hear Lisa there. Who were the other two male voices that we heard?
The defendant and then John Allerheiligen.
9B.
There's a guy attacking a parent in the Riverview parking lot. They just got into a car accident. He broke her window open. He's trying to pull her out of the car right now.
Okay. Which is it? Where
I
at?
witnessed it. Riverview Elementary School.
Riverview Elementary? Okay.
Yes, I witnessed. I can stay to be a witness. I'll put
Okay.
back in.
Yes, that would be good. All right.
Okay. Okay. Oh my God, he's attacking her. I
Okay.
think Ward's gonna need backup for sure.
Yeah, okay.
Guys.
All right.
Okay.
All right, we got people coming, all right?
Okay.
All right.
Bye.
Bye.
9C.
Safe location or emergency.
There was somebody that was shot in the Riverview Elementary parking lot.
Okay.
Car.
Okay.
Deputy Ward is here.
Okay. Do you know how old the patient is?
I don't know. I don't know.
They're in the
There's a
parking
guy-
lot? Okay.
No, he's already up.
Okay, hold on one
There's a
second.
man. Go this way. Go that way?
Okay, we're getting help. How old's the patient and where are they?
It's an adult. I don't know.
It's an adult?
It's an adult.
Okay, do we know where the shooter is?
Okay, he was outside. I don't know if the shooter was inside the car who shot the person outside the car or vice versa. I don't know.
Okay, so we don't know if he was in or out of a car?
There was one person out of the car banging on the other person's window, and then there was a man banging on someone's window. That person in the car, I don't know if they did the shooting or if the person outside the car did the shooting. I don't know which one it is.
Okay. And has that vehicle left?
Okay, I think they're still here. It looks like somebody's on the ground. It looks like a man's on the ground. There's a lady over there. I'm assuming Deputy Ward has arrested the other person. I don't know.
Okay. What's your name?
And lastly, 9D.
Do you have an emergency? Hello?
Hello, hi, this is Riverview Elementary School in Painesville Township. I believe there's a shooting in our parking lot.
Do you see anyone in,
Please send somebody.
they're already aware, ma'am. They're already aware. I need to
Okay,
know,
okay.
do you see anyone running away from the scene? Do you see anyone
I
hurt?
don't, I'm in the building.
Okay. What's your name?
My name is Gail Zarek.
Gail?
I'm the secretary, yes.
How do you,
Okay. When calls like this come in, a 911 call talking about a shooting in a school, what is the response that Lake County police departments have that might be different than a normal 911 call response?
So in this case, two things happened. One, the 911 calls, but somebody in the Riverview office, actually, there's a button in each of the schools that can be pressed if there is a school shooting or they believe there was a shooting. So that button was actually pressed, which notifies all Lake County agencies. And then in addition to the 911 calls, all Lake County agencies were notified that there was a shooting at Riverview Elementary.
And so what is the response then?
So at that point, every officer in Lake County that is on duty at that time, they begin to drive towards Riverview Elementary.
Not just the ones in that jurisdiction?
No, the countywide.
So even as far as Wickliffe, Willowick, they would start responding as well?
And as far east as Madison, yes.
Okay. And did that happen?
Yes, it did.
Now, quickly, once Lake County deputies arrived on scene, they learned that this was not a school shooting in the sense that normally you guys would prepare for, right?
Correct.
That this was more of a dispute between parties in the parking lot where a gun was fired, right?
Correct, yes.
And so once that was learned, what happened with the response?
So the responding deputies, they notified that they had the defendant in custody, or he was being detained at that point, that it was not, in fact, a school shooting, and that all the responding agencies outside of the sheriff's office could disregard.
Okay. Approximately how many officers, firefighters, emergency personnel responded to the scene?
Just in that short time before the deputies called everybody off, there was probably 4 or 5 different agencies that responded, and probably in excess of 50 law enforcement and fire personnel.
Okay. And what about the school? What did the school do?
And Riverview Elementary went into a lockdown.
Okay. What about Madison Avenue?
And Madison Avenue was shut down to the east at Bow Hall and to the west at Riverside Drive.
Okay. And I'll go to State's Exhibit 10 here. So this is just another photograph of the same scene we've been looking at, but showing the police cars and Madison Avenue in the background. Is that right?
Correct.
Okay. Now you mentioned that the defendant, after the gunshot, pulled out John. Is that right?
So after the gunshot, yes, he then actually removed John from the vehicle. He opened the front passenger door, removed John from the vehicle, and then began to continue to physically assault him outside of the vehicle.
Okay, and what about the gun? What was he doing with the gun at this time?
He had the gun to John's head at some point.
And was he saying anything?
You can kind of hear some of the stuff on the 911 call. Or the 911 call, he's talking about, "Do you want me to kill him? Do you want me to shoot him?" Things like that.
Okay. At what point did Deputy Ward approach this scene?
Some point in the background, you'll start to hear him kind of fade off. Deputy Ward approaches the defendant sometime during that 911 call that Lisa's making, and that's when he encounters the defendant.
Okay, and tell me what Deputy Ward did.
So Deputy Ward comes around the side of the vehicle. He draws his firearm in the direction of the defendant, and then orders the defendant to drop his firearm. At that point, the defendant throws. He's standing somewhere on the pavement here. He actually throws the firearm into the grassy area here, and then John is able to escape at that point. He runs around the front of the vehicle and goes over to this area. And at that point, Deputy Ward starts giving verbal commands to the defendant to drop to his knees, which he does comply with.
Okay.
Is she what?
He complied with that,
Okay.
yes.
Okay. Was Deputy Ward able to arrest or put the defendant in custody?
Yes, so Deputy Ward continued verbal commands. At that point, he asked him to lie flat on his stomach in the prone position. The defendant did not comply with that order. And then, at that point, seeing that the defendant had thrown the gun far enough away and that he had no other weapons on him, Deputy Ward then holstered his firearm and began to draw his taser.
Okay, what happened next?
At that point, the defendant stood up, charged at Deputy Ward, and then essentially speared him into the side of the enclave.
Okay, and what happened next?
So at that point, the defendant begins a physical fight with Deputy Ward. Deputy Ward stated the defendant grabbed at his firearm several times, trying to remove it from his holster, and Deputy Ward just essentially described that he was pretty much in a fight for his own life at that point. And at some point, he's able to get the defendant onto the ground and basically lay on him until some of the other deputies arrive. The other deputies actually take Deputy Ward off the defendant and are responsible for handcuffing the defendant. The other deputies will.
Does Deputy Ward ever deploy his taser?
He does deploy his taser at some point. As the defendant got up from his knees and charged at him, he attempted to deploy his taser, and that's when the defendant struck him.
Okay. State's Exhibit 11 here. This is the firearm as it was found in the grass after it was thrown.
Yes, it is.
And there's it's a Glock 26. Is that right?
Correct.
The magazine in this one appears to be a magazine that's extended past the butt of the gun. Is that right?
Yes, it's like a more compact gun, but that magazine is for a full-size firearm, so it'll still operate and still work, but it's meant for a full-size firearm.
And we see on the magazine there in white lettering the letters SI, and then it's cut off. Do you see that?
Yes.
Were you able to remove that firearm and determine what it said?
It says Sinclair.
And were you able to determine where this firearm came from?
It was the defendant's firearm.
Okay. Do you know where he retrieved it from?
No, he was on. It was on him at some point.
State's Exhibit 12 here. What are we looking at here?
This is pretty much when I arrived. This is kind of what it looked like. The defendant was in handcuffs. He was seated outside of the enclave. Once things had sort of settled down a little bit, that's a fireman standing there in the front of the picture, and he did get the defendant did get medical attention.
Okay. And we saw blood on the scene. Where did you believe that blood came from?
It came from the defendant's hands and his wrists. He cut up his wrist pretty good.
In taking out the window?
Yeah, from punching the window.
Okay. What about Deputy Ward? Did he suffer any injuries?
He did. He went to the hospital after this, and he suffered a dislocated finger.
And what about John Allerhagen? Did he suffer any injuries?
He did get some. He declined medical attention at the hospital, but he was treated on scene. He had some scratches, and he was cut up around his neck and around his arms. And then
I'm looking at States Exhibit 13A through D here. So this is photos of John's after the incident.
Yes, these were taken back at our office.
Okay.
It's John's neck. During the interview with John, he had on a baseball hat. He took his hat off at some point and ran his hands through his head, and then as he did that, a large clump of his hair fell out, which was likely done during the incident done by the defendant.
So what happened with the school? You mentioned the school was in lockdown. What is that? It was lifted from lockdown at some point?
Yes.
Okay.
What did you say is what?
It was lifted
Oh,
from
lifted.
lockdown?
Gotcha. Good.
What was the process like for that?
So once we had the defendant removed from the scene and some of the victims, the sheriff's deputies on scene, they coordinated with the school. They put out things through social media and through to email, and it was just a coordinated effort where parents were lined up on Madison Avenue. They were told how to respond if they wanted to come pick up their kid, and essentially there was like a check-in system between the deputies and the school, making sure one by one parents could retrieve their kids from the school if they wish.
And that required a significant number of police officers to coordinate?
Yes, police, fire, and school staff.
Did you remained on scene this entire time?
Yes, I did.
Did you have a chance to observe any of the parents that came to pick up their kids?
Yes.
And just generally, how would you describe what you observed in their reactions?
A lot of hysterical parents, because most of them didn't know at that point whether there was an actual school shooting or what the circumstances were. They just know that there was some type of a shooting incident in their parking lot during the drop-off period. So there was a lot of uncertainty, a lot of hysteria, concern for the safety of their own children.
Okay. And how long did the area remain closed, approximately?
Probably until about 1 or 2 p.m.
All right, let's talk about what happens in court after this. So the defendant is arraigned the next day at the Painesville Municipal Court. He's charged with some initial charges in the Lake County Sheriff's Office, is that right?
Yes.
And were you there at his initial arraignment?
Yes, I was.
Okay. As a part of any orders that the court gave, did the court issue a protection order at all?
Yes, they did.
Okay. And was the defendant present when that order was issued?
He was present via video, yes.
Okay. And who was the protected party under that temporary protection order?
Lisa Chorba and the 3 children, Charlie, Sebastian, and Carson.
Okay. And move to...
This is the very next day?
Yes.
State's Exhibit 14 here. What are we looking at State's Exhibit 14?
This is the initial protection order that was granted. It was part of the arraignment. It was granted by Judge Malcheski. And this order was then served immediately after the hearing. The bailiff from Painesville Municipal Court went over to the jail and served Alexander with a copy of this order.
And this order, in part, prevents the defendant from contacting or attempting to initiate contact against any of the protected parties. Is that right?
Correct.
So this was on November 1st?
Yes, it is.
Okay. Once the defendant was booked into the Lake County Jail, did he call or attempt to call Lisa Chorba or any of the protected parties after this order was issued?
Yes, he did.
Okay. Which day?
So the first phone call that he attempted to Lisa was going to be on November 3rd.
Okay. And here, State's Exhibit 15, we see some highlighted portions of the defendant's jail call log. Do you see that?
Yes.
And all these highlighted portions are the same phone number called out. Is that right?
Yes.
And whose phone number is that?
The 440-477-5776. That's Lisa Chorba's cell phone number.
When somebody's in the jail making jail calls, are people able to call into the jail to speak with an inmate?
No.
Okay, all the calls have to be made from the inmate going out. Is
Yes.
that right? Not all of these calls actually were completed in the sense that there was a conversation between the defendant and Lisa, is that right?
Correct. There was only 2 phone calls that were completed where a conversation, or 2 phone calls on the 3rd.
Okay. And then there are a number of calls after the 3rd?
Yes, there's 2 on the 4th, and then there's another one on the, there's a couple on the 5th that are attempted, but they are not picked up.
Okay. And then,
there's additionally, there's a 2 calls on November 29th.
did you have an opportunity to listen to these calls?
I did.
Okay. And anything significant that you found on these calls, especially some of the initial ones?
In the first 1 or 2 phone calls, there was some discussion about the incident, why it happened, how it happened, things like that. And the defendant makes reference to his mental health and his state of mind at the time that this happened.
Okay. I'm going to play States Exhibit 22A through C now. You had an opportunity to listen to these calls prior to coming to court?
I did, yes.
And these are portions of jail calls from the defendant to Lisa Chorba?
Yes.
And what day did these calls take place?
November 3rd and November 4th. Actually, I think these were both November 3rd.
Right.
I know, but you didn't even know that.
I know. And that's what my issue is. I just breaking down mentally. I just lost.
Yeah.
I broke down mentally. And
I know, but I've been asking you for months.
I know. And that's what I told them. I said, man, I got my wife to talk about this, and I need to go get help. And all this happened, and now this is it. And I ruined my entire life. Like, I lost.
22B?
So you really think that you're having a psychotic break?
I don't know, just based on everything. Like, even the day before, I thought was,
At your mom? At my mom?
Yeah. Just
Yeah,
like,
weird.
She was just like, yeah, you need to get looked at. I was like, yeah, you're right. And then once it happened, and whatever.
And lastly, 22C, which, for the record, I don't believe was on my exhibit list, but I just moved to amend that exhibit list to show 22C.
My world, and I'm sorry, I just lost it.
Yeah, I know you lost it. It's a lot to handle.
I'm sure. You were my world, and I'm so I love you so much.
I just have so many questions.
I know. Your mom, I talked to your mom the day before, and I was like, yeah, like, I'm going to try and get through Halloween, and then, this, and I'm going to go probably check myself in.
Yeah.
And then this happened, and now it's just
Yeah. What were you thinking?
I don't know. I wasn't. I just blacked out, and I'm just so angry and hurt and sad.
In one of these initial calls, we didn't hear it in the exhibits, but you listened to one of these initial calls in which Lisa actually tells the defendant that by talking to her, he's breaking the restraining order issued by Paynes Municipal Court. Did you hear that?
Yes.
And he continued to call or attempt to call her even after that statement?
Yes.
Lisa also went to this court, this Lake County Court of Common Pleas to get a CPO, is that right?
Yes.
Okay. And what day did she initially go to apply for that civil protection order?
So she applied for that on November 1st, and then it was served to the defendant on, there was a hearing held, an ex parte hearing held, and then it was granted, and then it was served to the defendant on November 4th.
Okay, so she applied for this order after Paynesville's arraignment, is that right?
Yes.
Okay, and so she gets the ex parte order on the 1st, and that is served upon the defendant, like you said, on the 4th?
Yes.
Okay. And again, she and her kids are the protected parties in this civil protection order?
Yes.
And in part, this order prevents the defendant from contacting or attempting to initiate contact with the protected parties?
Yes.
17A, what are we looking at in 17A?
This is a copy of our, what we call a warrant jacket at Lake County Sheriff's Office. It's what holds all the paperwork for warrants or civil orders. So this is going to be right here. This order was served to the defendant by Deputy Leonello at 10:45 in the morning on November 4th, 2024, and then where it says service, it says personal. He was, the defendant was in jail, so he was served while he was in jail with a copy of the protection order.
And 17B?
This is the return of service, so this is just the paperwork that Deputy Leonello would complete that says I served the defendant with a copy of the order, and then it's dated and signed.
Let's go back to the civil protection order here at Exhibit 16. This was initially granted ex parte on the 1st. Was it ever granted in full?
Yes, it was.
And what date was that?
November 13th, 2024.
And was the defendant served with a copy of this order after it was granted in full?
Yes, he was.
And how do you know that?
Because there should be this is a same thing. It's a return of service. So it was served to the defendant on November 13th, and whoever served it to him, his signature's on there somewhere. And then it was served at 3 o'clock p.m. on the 13th to the defendant.
And you're aware that the defendant was indicted in the case we're here for today on December 16th, is that right?
Yes.
And part of that indictment included charges of violating protection order for the conduct that we just discussed here today in contacting Lisa.
Yes.
Okay. After that indictment, or around that indictment, did the defendant attempt any additional contacts with Lisa Chorba?
Yes, he did.
Okay, can you describe that?
So in addition to jail calls we have inmates can send text messages, essentially off of a tablet. In order to do that, they have to what's called connect with somebody on the outside. So somebody on the outside would have to create an account. The defendant can then reach out to them, request to essentially be friends with them through this connection, and then they can, if that's accepted, they can communicate via text message between somebody on the outside and the person in the jail, the inmate.
Okay, so State's Exhibit 19A here, this is a document from Lake County Sheriff's Office?
Yes.
And it's titled Phone Invitation Report for Alexander Sinclair. Do you see that?
Yes.
And what is this document telling us?
So this shows you that on December 18th, 2024, at 10:03 p.m., the defendant sent essentially an invitation which appeared to Lisa as a text message, and it said, hey, there's somebody in the jail that wants to connect with you, and then the defendant used Lisa's same number to reach out and make a connection.
Okay, and did Lisa make an account and accept this request?
Yes, she did.
And we're looking at Exhibit 19B here, and is that what this shows?
Yeah, so the bottom one, that's going to be Lisa created her account December 18th, 2024, 11:33 p.m. She sends some type of a connection request or some form to the defendant, and then that's accepted by the defendant at the following day at 10:15 in the morning on the 19th.
December 19th.
December 19th, 2024.
Okay. Now, State's Exhibit 20, what are we looking at in State's Exhibit 20?
This is just a copy of all the text messages that are sent by the defendant to whomever on the outside.
And I'll scroll down here to the highlighted portions. And the highlighted portions, who are these going to according to this document?
So these are between Lisa and the defendant. The defendant sent he sent the first message to Lisa on December 19th. Lisa did reply to that message. And then after that, the defendant sends 6 additional messages to Lisa. None of those, Lisa did not respond to any of those.
Okay. And those messages were sent on December 19th and December 20th, is that right?
Correct.
Okay. And to your knowledge, the civil protection order was still in place at that time?
Yes, it was.
Lastly, I want to talk about the defendant's employment. Initially, you had stated that you learned the defendant was a Cleveland police officer, is that right?
Yes.
What is his status right now with the city of Cleveland?
He's currently on unpaid administrative leave.
Pending the outcome of the criminal case here in Lake County?
Correct.
Okay. Prior to this incident on October 31st, were you made aware of any significant misconduct or disciplinary actions against the defendant in his work capacity?
Yes.
And can you describe that?
I believe it was on October 1st of 2024, the defendant was issued a 6-day suspension, and that stemmed from an incident which occurred sometime between 2021 and 2022, in which the defendant, who was a detective with Cleveland Police at the time, engaged in sexual conduct on duty in a city vehicle with another Cleveland Police detective.
And where did that occur? You said inside of a vehicle, but where?
It was inside of a city vehicle, and then it occurred in the parking garage of the Justice Center in Cleveland.
Why did it take Cleveland so long to address this issue. You said it was issued in 2024, but the conduct was in 2021 to 2022. Based on your investigation, what took so long?
So according to the personnel file, there were essentially rumors that this had occurred that surfaced well after this incident actually occurred. The Internal Affairs Department at the Cleveland Division of Police, they conducted their investigation, and the defendant and the female who he was engaged in sexual conduct with both admitted that this occurred, but that admission didn't come until later, probably 2023, 2024, and the investigation was completed in October of 2024.
And as a result of that, the defendant was placed on a temporary suspension starting in October 2024.
He was issued a 6-day suspension.
Oh, was there any other misconduct or disciplinary action related to this incident?
Yes. So
Which incident? This incident?
I'm sorry. Let me back up to the Cleveland internal.
Okay, gotcha.
Yes. For this internal investigation, in addition to the sexual conduct, they discovered that the defendant had been issued what they called a commuter vehicle, so he was given a city vehicle to drive. And when they went in their investigation, they were checking logs to determine when he would have been operating this vehicle. He failed to ever complete a log that he was using a commuter vehicle, so they disciplined him for failure to report his commuter vehicle log.
Okay. And approximately how long had the defendant been employed by the Cleveland Division of Police?
He was hired in 2015.
You did discover some other minor disciplinary things or documentations on his record, is that right?
Yes.
And just generally, what were those related to?
One involved abuse of sick time, and the other one was, as a supervisor, he failed to review sick time logs or something like that from his subordinates.
Okay. Did you interpret those as significant violations?
No.
Okay. And to your knowledge, the defendant has no criminal record or criminal history?
Correct.
Your Honor, I have no further questions.
Thank you. Cross-examination, Ms. Smith.
Good afternoon.
Good afternoon.
Smith, counsel for the defendant. I just want to follow up on a couple of the topics that you touched on with Mr. Downing. The first, Mr. Downing asked you if there was any reason for Mr. Sinclair to be at Ms. Chorba's job.
Correct.
You indicated that there was not. Now, you've also indicated that you're aware that Mr. Sinclair and Ms. Chorba have been married for 4 years.
Yes.
What date did they get married?
October 31st, 2020.
So what was the date of this incident?
It would have been their 4-year anniversary,
It would have. Would he have any reason to go visit his wife at work on the 4-year anniversary?
I suppose.
When you searched his car, was there a anniversary card in it? In a blue envelope?
I don't recall off the top of my head if there was or not.
Would it surprise you to learn that it was in light of the fact that it was his anniversary and he just drove to her work?
No.
Throughout the course of your investigation, at any point, did you obtain any information that would lead you to believe that prior to that day, Mr. Sinclair had any awareness of John or had any reason to believe that Lisa was sleeping with or engaged in any sort of relationship of a romantic sort with anyone other than Mr. Sinclair?
No.
Mr. Downing, could I have your Exhibit 4A? Now, you were asked...
This is for the record for...
I'm sorry, for the record, this is Exhibit 4A.
4A.
4A? I didn't...
Exhibit
Okay,
4A.
thank you.
When you were asked to describe John in this photo, you said he's the white male. So who's Mr. Sinclair?
Mr. Sinclair is a black male.
Now, when we were talking about the gunshot through the windshield, when you and Mr. Downing were, you indicated there was one bullet fired. The path of travel indicated it was from inside the vehicle to outside. Do you have any reason to believe that Mr. Sinclair was shooting at his own vehicle? Intentionally?
Intentionally? No.
Do you have any reason to believe that Mr. Sinclair intended to harm anyone with the bullet that was ejected from his gun that morning?
No.
one thing that is mentioned in this, both in the state's brief and was addressed during direct exam is the official response for when a potential school shooting comes in. You've indicated that all agencies are notified and all on-duty officers respond from the county.
Yes.
So what happens when a false school alarm is called in? If somebody reports a school shooting that doesn't happen and then commits a crime somewhere else in the county?
So we've had like that. I mean, it's happened before. Where people like accidentally press the alarm or things like that. So if that is activated, then yes, it's everybody responds until told otherwise.
So if somebody wants to commit a crime in Lake County, they should just call in a school shooting.
What does that have to do with anything here?
Fair, withdrawn. Mr. Downey asked you about the first hearing that was held in Paynesville Municipal Court.
Yes.
You discussed who was present. Because you were there and I was not, was Mr. Sinclair represented by counsel at that hearing?
At the initial arraignment, no.
And when going through the phone logs from the jail, there was a 15-minute call. Does that suggest that it was answered?
Not necessarily. I mean, not necessarily. I mean, if there was a recording or something, if there's an open line on the other end and nobody hangs up, it'll keep recording until somebody hangs up, or it times out at 15 minutes.
And in your review of the recorded jail calls, did you notice anything said by Mr. Sinclair that would constitute a threat?
Threat of?
A threat to anybody. Did he make a threat in any of his jail calls? Would it surprise you to learn that he did not?
He made threats of self-harm, I guess, but no, not towards anybody else, no.
Did he express remorse?
Yes.
Was he apologetic?
Yes.
Was he frequently tearful?
Yes.
Did he express that he loved his wife?
Yes.
Did he express that this was overwhelming for him?
Yes.
And you've described the disciplinary action against Mr. Sinclair as is described in the overview letter, that it was sexual conduct. Did you do any further investigation to learn the nature of that conduct or contact?
He received oral sex from a female on more than one occasion, the same female, while on duty in a city car on city property.
Did you have opportunity to read the transcript of the disciplinary hearing?
I did not.
Would it surprise you to learn that what you just put on the record is inconsistent with the transcript of the disciplinary hearing?
I've never read the transcript.
No further questions?
Thank you. Redirect examination?
No, Your Honor.
Thank you, Detective.
Thanks.
Does the state have any further witnesses?
No, Your Honor.
Move for the admission of your exhibits?
Yes. And they are all
Is everything on the list plus one additional one? I can't remember.
22C. It's listed on the exhibit list as 22A through B.
Right.
So just add C with the same description, and all of the exhibits are contained on a flash drive, which I've marked as bond hearing states exhibits, and I'll provide those to the court for.
Any objection to any of those exhibits, Ms. Smith?
No objections.
All right, those all will be admitted then. You have a copy of that list, Mary? All right. Does the defense have any witnesses?
Your Honor, we do have one witness. The defense would call Katari Lundy.
Good afternoon. Please raise your right hand. Do you swear or affirm the testimony you're about to give here will be the truth, the whole truth, and nothing but the truth? Have a seat. Ms. Smith, whenever you're ready.
Mr. Lundy, would you please state and spell your name for the record?
Katari Lundy, Katari, last name Lundy.
And Marshall Lundy, where are you employed?
Lake County Public Defender's Office,
What is your role at the Lake County Public Defender's Office?
Chief Investigator,
How long have you been the chief investigator there?
3 years.
Prior to becoming the chief investigator for the Lake County Public Defender's Office, did you have any additional investigative experience?
Yes,
Could you summarize that experience for us?
I was an investigator for the Cuyahoga County Public Defender's Office.
And what years were you employed there?
2018 until, 2017 to 2019.
And as it pertains to Mr. Sinclair, at any point, were you asked to do an investigation in preparation for this hearing?
Yes.
And as part of your investigation, what steps did you take?
So I spoke with an uncle, his maternal uncle, Mr. Richard Sinclair. I also spoke with his mom, Miss Sandra Sinclair, and I also spoke with Mr. Alexander Sinclair, and I requested his personnel file from the Cleveland Police Department, and I searched the Cleveland 5th District Police Department's website, Facebook page.
Did you do any additional research into the crime in the area where Mr. Sinclair worked?
Yes.
Now, you requested Mr. Sinclair's personnel file. Did you receive the file in full?
I received partial.
What portion of Mr. Sinclair's personnel file did you receive?
It was mainly the disciplinary records or reports.
Now, you heard the disciplinary action that was addressed with Officer Wren.
Yes.
What stood out to you when you received the disciplinary file and that was all it contained?
It didn't have his, his resume or application. What are you referring to? I'm sorry.
So there was no record of his training, any awards he had received, his promotions, and those.
Correct. Correct.
In other words, you received only the negative portion of his file.
Correct.
Now, when you reviewed the disciplinary file, was there any record of any unjustified use of force?
No.
Was there any record of any unprofessional conduct or interaction with any member of the public at any time?
No.
During your interview with Mr. Sinclair, did you learn how long he worked with the Cleveland Police Department?
Yes.
When did he begin his time with Cleveland Police?
In 2015.
And so from 2015 through 2024, there are no allegations of unprofessional conduct or interactions with members of the public, no unjustified use of force, or anything other than what has previously been addressed?
No.
Now, at any point in your investigation, did you come to learn what Mr. Sinclair's rank is?
Yes. He was a sergeant.
And what district was he stationed at?
He was a sergeant at the 5th District Cleveland
On what
Police
shift?
Department. I'm sorry?
On what shift?
Third shift.
What can you tell us about 5th District in Cleveland on third shift?
5th District is one of the worst areas in Cuyahoga County. It includes Glenville and the Collinwood area. It's a high crime area.
Now, when you say high crime area, it's a phrase that's used in every county in the state when we talk about criminal proceedings. When you say a high crime area in Cleveland, does that mean the same thing as a high crime area in Lake County?
No.
Do Do you know what the average homicide rate is annually in the city of Cleveland?
Not exactly, but I'm sure it's higher than Lake County.
You would be correct. Now, you conducted interviews with Mr. Sinclair's uncle, his mother, and had multiple meetings with Mr. Sinclair. How old is Mr. Sinclair?
He's 34.
Did he attend college?
Yes.
Where did he go to school?
He went to Hiram College.
How old was he when he started attending Hiram?
16 years old. 16 or 17 years old.
Did Mr. Sinclair complete his education at Hiram?
Yes, he graduated with honors.
And how many majors did he have?
How many what?
Majors,
Oh, majors,
did he
I'm
have?
sorry.
2 majors.
Do you recall what those were?
I believe they were sociology and political science.
How did Mr. Sinclair pay for a portion of his college education?
He received an academic scholarship.
Did he engage in any extracurriculars or athletics while he was a student at Hiram?
Yes, I believe he played football.
Does Mr. Sinclair speak any foreign languages?
He speaks Russian.
Does he play any musical instruments?
He's a violinist.
And as has been established, he is currently employed with the city of Cleveland as a sergeant.
Yes.
And you indicated that he started there in 2015. How many promotions that you're aware of did Mr. Sinclair receive in the 9 years he's been a police officer?
I believe he was a detective, and then he became a information officer and sergeant.
Do you know how long it took him to make detective?
I want to say 4 years.
And he was a sergeant within how many years?
Let's see, I think I took some notes. Uh, 3 years.
3 years after becoming detective?
Yes.
And Mr. Sinclair is married to Lisa Chorba. There are 4 children in their household. What did you learn about Mr. Sinclair's relationship with Lisa's children that were not his biological children?
That he adopted him as his own.
Now, were you able to confirm that he legally adopted them, or were you able to confirm that he legally adopted them?
No.
But it's your understanding that he raised these 2 boys as his own?
Correct.
Does Mr. Sinclair live in Lake County?
Yes.
How long has he lived in Lake County?
He's lived in Lake County for 8 years.
And does he own property in Lake County?
Yes. He purchased a home. The home on Palm Avenue.
Does Mr. Sinclair have a criminal record?
No.
Does he have any history of failures to appear?
No.
Is there anything else about the interviews that you conducted with Mr. Sinclair, his mother, his uncle, any additional facts that you would like the court to know?
He's always wanted to be a policeman as a young child. His idea was to make the police force, make policing better, and to make it a better image from the inside out. He also graduated at the top of his class from the academy, and he was a platoon leader.
No further questions.
Cross-examination, Mr. Downing.
Thank you, Your Honor. Hi, Mr. Lundy.
Good afternoon.
Do you have any, prior to becoming an investigator, did you have any law enforcement training?
No, sir.
Okay. What type of training did you have that eventually led you to become an investigator?
I started off as a child protection investigator for the Cuyahoga County Children and Family Services.
Okay. Did you, it sounds like based on your questioning from Ms. Smith that you didn't review any of the crime statistics with Cleveland or Cuyahoga County based upon Lake County. Is that fair?
Yes.
Okay. And you mentioned that you testified that you requested the personal record from Mr. Sinclair for Cleveland Police, right?
Yes, sir.
And when you said that you received what only appeared to be like the negative things, the disciplinary actions, that's something that Cleveland Police sent to you?
Yes.
Or is that something that the prosecutor's office sent to the public defender's office? Or maybe both?
It was from the request from the Cleveland Police Department.
Okay. And what significance is that, if any, to you that you only received the negative things about his employment?
Well, I would like to have received his promotions, some accolades, some awards he received, some of the good things that he's done.
Okay. And would that help at all in your ability as an investigator?
In my opinion, I think it paints him in a better light.
Okay. And as an investigator with the public defender's office, are you physically in the same office as the public defender attorneys?
Yes.
Okay. And so it's, when you go to work every day, you're seeing the same people that you're working with. Is that fair?
Correct.
Okay. And I'm assuming you have discussions about, the cases that you would be investigating on prior to like testimony or things like that?
Sure.
Okay. So then you would also be aware that the state of Ohio sent the public defenders in this case full records of the defendant's personal file to include over 200 pages of training and commendations and his record and the things that you said were missing back on January 10th. You were aware of that?
I saw something in Discovery, but I did not go through all of it.
Okay. And you're aware that are you then aware that the public defender's office then downloaded that file on the 13th at 10:23 a.m. prior to today's hearing?
I'm not sure of the exact date, sir, no.
Okay. So were you not aware that you actually had the full personnel file, or did you just fail to review it prior to coming in today?
I wasn't aware we had the full personnel file.
Okay, thank you.
Redirect examination?
Just briefly. Mr. Lundy, when you opened the discovery file for Mr. Sinclair, do you know how many files were present in there?
I do not.
Were there multiple files that contained multiple documents?
Yes.
Were there multiple files that contained hours upon hours of videos, recordings, jail calls, etc.?
There were very a high amount of files in that folder.
Would it be within the realm of human capability for you to have reviewed the entire discovery file for Mr. Sinclair prior to coming to today's hearing?
No.
Thank you.
Mr. Downing, recross?
Are you aware that the discovery package sent to the public defender's office with the full personnel file on the 10th contained only the personnel file and nothing else?
No.
Okay. And if you received a package that contained only one document, fair to say that'd probably be easier to review than a package that contained many, many documents?
Repeat that?
If you received a discovery package that contained one document, one file, that would be a lot easier to sort through than a discovery package that contained hundreds or thousands of files.
Yes.
Okay, thank you.
All right, sir, you may step down. Thank you. Let me call your next witness, Ms.
We have no additional witnesses, Your Honor.
Downing. Anyone else?
No, Your Honor.
All right, do you care to make any closing comments, Mr. Downing?
I will, Your Honor. As the court is aware, the bond issue in this case is constricted to the 2 counts of F1 kidnapping and the single count of felony 2 improper discharge of a firearm on a school premises. Based upon the evidence that I believe was presented today, it is the state's contention that proof is evident and that the state has met the burden of proof, being that the presumption is great that the defendant in this case committed these 3 offenses of which he is charged. Looking at, and this is based upon multiple witness accounts, photographs, video, multiple police officers, surveillance video, multiple interviews, I believe that the presumption there, or the burden there is met. As far as the other 2 factors that the court must consider under this statute 2937.222, the state does believe that the defendant in this case poses a substantial risk of serious physical harm to people in the community, and that no release conditions will reasonably assure the safety of those people and the community. And when I address those, I address them together because I think you have to look at all of the offenses in this case together, because this is really one kind of event from start to finish.
Well, it's not just the community. It could be to any person or the community.
Correct. And in this case, I believe it's both. First and foremost, there's an obvious threat to the people that are closest to him, the main victims in this case, and those being Lisa Chorba, John Allerhagen, and the children. As we heard, that he showed up unannounced. He began immediately a physical altercation against an individual, Mr. Allerhagen, that he had no previous interactions with. And then after the initial incident at the parking lot of Child Time, continued down Madison Avenue, driving recklessly at a high rate of speed, putting himself and others in the road in danger, and then restarting this event at the school, which was more crowded, and escalated his actions to ripping out the window, pointing a gun, firing off a round, assaulting John, causing him physical harm, pointing a gun at his head, threatening to kill him, dragging him out of the car, pointing the gun at his head again, threatening to kill him again, and then fighting with Deputy Ward. He did initially comply with Deputy Ward in that he tossed the gun and dropped to his knees, but then stopped complying, charged Deputy Ward, pinned him up against the car, went for his firearm, which I know is not charged in this case, but I believe is relevant to the court's consideration. And it wasn't until Deputy Ward deployed his taser and other deputies arrived on scene, they were able to subdue the situation. And this is despite the fact that there are many people yelling, screaming. Lisa's yelling at him to stop. He's bleeding everywhere. And it just, for whatever reason, he kind of saw past all that and continued doing what he was doing. So that is a danger not only to the people around him, but the police officers, or the police officer in this case, and the community at large. And this is a school that initially the calls came in as a school shooting, and I know that's not in what we believe that term to be what it ended up being, but the school didn't know it at the time and resulted in an immediate lockdown. There were messages sent to parents, as we heard, that caused them to come to the scene hysterical, upset, hearing that there's a shooting where their school, they just dropped their kids off, and then minutes later there's a shooting there. There was a large-scale, slow, and coordinated effort to release all those kids to the parents that required the extensive law enforcement. The road was shut down. This was a great impact to this community, not only on this day, but continues to be. This is something that is now a formidable moment, I would imagine, in many of these kids' minds, that they're showing up for Halloween on a day that's supposed to be happy and in their costumes, and instead they're placed in immediate lockdown because somebody's shooting a gun off in the parking lot. This is not something that is forgotten. And this is a parent's and a teacher's and an administrator's worst nightmare when they think about what it's like to send their kids to school or watch over kids. And it's the defendant that caused all of this. And on top of that, he's a police officer. He took an oath and swore to protect the community, and instead, he's being a menace to the community. So his actions here not only affect those immediately around him, but the community at large, the school, the neighborhood around there, other schools in the area, the impacts, I can't bring everybody in to describe all of that because I think we'd be here forever. So the fact that this turned into what appears to be a domestic dispute that I would imagine would be very upsetting to people involved, into what it became, I think, is unreasonable. This is something, unfortunately, that we see a lot of. People either going through mental health issues combined with some kind of domestic dispute where spouses are cheating at each other, and I understand that. But to take this into a multi-scene incident where the defendant is attacking police officers, shooting off guns, attacking somebody he doesn't even know, and doing everything that he did in this case, putting everybody at large, I think is way above and beyond what would be even remotely reasonable. And we don't know why he did that. He claims that in the jail calls that he had a mental breakdown. He references a psychotic break. He references that prior to this he was going to get himself checked in. I don't know how much of that relies or how much of that is related, but at the very least he's unpredictable. And there's no reasonable explanation for why this happened in the first place. And the relationships that caused this event continue to exist even today. So if he were to be out, I believe he does pose a danger to the people around him, and he poses a danger to the community. Lastly, and I bring this up because I think is it important, that even when told in person and via service multiple times under the initial Painesville Municipal Court TPO and the civil protection order, he continued to violate that order. He continued to contact Lisa even when she told him, hey, you're violating this order. Even when he was told multiple times under multiple orders he cannot do that, he ignored that. He was indicted in this case for violating a protection order and continued to violate the protection order. So if he cannot be trusted to follow the law when he is here in jail, I don't see how he can be trusted to follow the law when he's out. He's a police officer, he's a citizen, he has all these reasons to follow the law, and he's ignored all of that. And so from the state's perspective, I don't see how he can be reasonably assured to comply with the law, and I don't believe any bond conditions can reasonably assure his release. I will just note, lastly, as required under Marcy's law, the state did contact the victims in this case, Lisa Chorba and John Allerhagen, as it pertains to those offenses. They they would request that the defendant be held without bond. I know that's not a consideration for the statute, but I just put that on the record as well.
Ms. Smith?
Thank you, Your Honor. Please, the court. Bond factor's been addressed through the testimony of both witnesses.
The what is?
The bond factors for the court's consideration have been addressed through both witnesses. But in summary, the state went on at length as to the evidence of this offense, in part because it's a relevant factor, in part because it's all that's there. Mr. Sinclair was a model child, was a model citizen, and was a model police officer. He, on his 4th wedding anniversary, went to take a card to his wife at her job, and for the first time ever learned that she was cheating on him. His response that day, recognizing that he is before this court cloaked in the presumption of innocence, but assuming for the sake of argument, giving full weight to the state's evidence for purposes of this hearing, he was heartbroken. It's reflected in the jail calls. His whole world was turned upside down in that moment, and he reacted poorly. The thing is, that moment is not likely to repeat itself, even though the relationship continues today, because the initial shock of that moment and that realization has worn off. Mr. Sinclair is absolutely amenable to whatever conditions the court may place to assure both his appearance for his court hearings, as well as to assure the safety of the public at large and any individual within the community. If released on bond, Mr. Sinclair will be residing at his mother's house, which is in South Euclid in the county of Cuyahoga. Ms. Chorba resides and works in Lake County, in the city of, in Lake County. Were there any failure of Mr. Sinclair to comply? He is offering to be placed on GPS, and an intervention could absolutely be made, either to prevent Mr. Sinclair from reaching Ms. Chorba or to escort Ms. Chorba to safety. However, that will not be necessary, as is reflected in Mr. Sinclair's jail calls. He is heartbroken. He is sad. He's depressed. He is concerned about his own mental health and would like to seek treatment on the outside. But what he is not is a danger to himself, to Ms. Chorba, to any of the other victims in this case, or to the public at large. In fact, he was a trustee of the safety of the public at large up until this incident. And he did so in one of the most violent districts, probably in the state of Ohio, let alone in Northeast Ohio, on the worst shift where most of the homicides take place. And he did it despite the toll that it took on him, despite the toll that it took on his relationship. Additionally, we would ask the court to consider, first, that the conditions of Mr. Sinclair's incarceration, while he's being held in a jail simply because of his status as a police officer, he is held in isolation. Mr. Sinclair has been in isolation for 2.5 months. Isolation can only be used for discipline, for limited purposes of time, because of the effect and the toll that it takes on the psyche of a person who is subjected to it. Mr. Sinclair could be placed on home detention with electronic monitoring at his mother's house. He could receive therapy. Ms. Chorba will be safe. Mr. Sinclair will be safe. Their children will be safe, and so will the public at large. The state highlights the fact that Mr. Sinclair is a police officer as some reason that he should be held to a higher standard, but the Ohio Supreme Court does not agree with that. They held in State v. Mole that creating separate classes of peace officers in order to subject their off-duty behavior to criminal sanctions on the basis of strict liability is not rationally related to governmental interests in maintaining public confidence in law enforcement, ensuring integrity of its members, or another unrelated factor to the issue at hand. Mr. Sinclair is a police officer. Mr. Sinclair is also a human being. Mr. Sinclair is also a husband, and he is also heartbroken. Additionally, Your Honor, our office in preparation for this hearing did pull for a comparative study all of the bonds in place on felonies of the first and second degree, and where there is not a decedent involved. No bonds are rarely used in these circumstances. The examples we found for no bonds are an individual with no prior criminal record who was facing 2 life rapes. He would not have been able to afford any bond if one had been granted. However, people charged with multiple counts of rape, strangulation, kidnapping are routinely, by the courts in this building, given bonds that are $500,000 cash surety or 10%. The boom around this event was huge, but the harm in comparison was small. Without minimizing the seriousness of what is alleged to have occurred that day, John declined medical attention, and I do not intend to be disrespectful, but I cannot pronounce his last name. In fact, the person who was harmed most physically in this event was Mr. Sinclair. We have Mr. Sinclair's blood all over the vehicle. John with some scratches that did not need additional medical intervention, and a police officer with a dislocated finger. That is harm. We're not trying to erase that. But that harm is minimal when we look at the cases
You're considering just physical harm.
The physical harm.
Not psychological harm. For the hundreds of kids that were at the school there that day.
I wouldn't minimize that. But when we are comparing apples to apples, Mr. Sinclair is a person with no criminal history, with no history of failing to appear He lawfully owned the firearm that he was carrying that day and was carrying it legally. And Mr. Sinclair is accused of conduct that is absolutely egregious, and he's facing a serious potential prison sentence. However, there are hundreds of defendants that come through this court on an annual basis who are facing serious charges, who have serious criminal records, who have caused serious physical harm that with documented proof, and they are routinely provided bonds, $500,000, 10% cash surety, $300,000, 10% cash surety, $250,000, 10% cash surety. We're asking for a $500,000 cash surety, 10% bond. That is by no means an insignificant bond, and it is on the high end of what is usually imposed for people with far more serious criminal histories than Mr. Sinclair, and with victims who are permanently, irreversibly, physically harmed from the alleged conduct. The question before the court is not whether or not it thinks that Mr. Sinclair is guilty of the offenses. The question before this court is whether or not he is suitable for bond. And under every legal factor that's available for the court's consideration, Alexander Sinclair absolutely warrants a bond. He's not a flight risk. He poses no threat to anyone at this time. He will obtain a mental health evaluation as a condition of his bond, and he will voluntarily subject himself to GPS monitoring. He conceded to the protection order, and although there were violations...
What do you mean he conceded to it? He didn't contest it?
He did not...
He didn't appear and argue against, oppose it, I guess is the word.
I believe that the CPO was initiated in Paynesville Municipal Court.
That's the first one, but then there was one filed in domestic court, which an ex parte was granted, and then 2 weeks later, a hearing was scheduled for the final hearing.
Correct, which Mr. Sinclair obviously could not attend because he was on a no bond in the Lake County Jail. The first CPO requested. The first CPO requested was Mr. Sinclair agreed to without question. Mr. Sinclair was in isolation, away from his children for the first time in his life on a holiday, spiraled, and reached out to Lisa. He has had no...
What holiday was that?
I'm sorry?
What holiday are you talking about?
So there was...
It was over a lengthy period of time.
Correct. Between Thanksgiving and Christmas. So after experiencing the first holiday without his
he
children...
was contacting her at the beginning of November by phone. Am I wrong about that?
Started on the 3rd.
Yeah, all right.
Mr. Sinclair has not attempted to reach out to Ms. Chorba in a month. If this court grants him a bond, he will not reach out to Ms. Chorba or any other protected party in this. And if he does, the court can revoke his bond.
Mr. Downey, any rebuttal? You don't have to. I'm just making sure, give you a chance.
No, Your Honor, I'll stand on my own.
Court's going to take a brief recess and I'll reconvene.
All rise.
right, this court has considered the motion filed by the state of Ohio. I've considered the evidence presented at this hearing. I've considered the arguments of counsel, Mr. Downey and Ms. Smith. All of this is considered in light of the standards set forth in Revised Code Section 2937.222. And considering all the foregoing in light of this standard, the court does find that the state of Ohio has established and met its burden in proving by clear and convincing evidence that the proof in this case is evident and the presumption great that the defendant did commit the felonies of the first or second degree for which he is charged. This is not a whodunit. And there's no question in this case that the defendant, at least in regards to this burden, that the proof is evident that the defendant engaged in this conduct and committed those felonies of the first or second degree. I think there's 3 of them in this particular case. So the state has met its burden in that regard, in that prong. As to the second and third prong, the state's required to show that the defendant poses substantial risk of serious physical harm to any person or to the community, and that there are no release conditions that will reasonably assure the safety to that particular person or the community. In this case, the court finds that the defendant does pose a substantial risk of serious physical harm to the 2 victims in this case that were in the car, and to the community. It was said during closing that everybody will be safe. I don't know how you can say everybody will be safe in the community and nobody won't be safe. I disagree with that. In this particular case, nothing stopped the defendant. He approached the victims at the daycare. They left. He followed them to a school with children at this school, with witnesses all over. None of that stopped him. He approached the vehicle with a firearm, with witnesses there, kids there. His own 2-year-old child in the back seat of his car. That didn't stop him. Discharged the firearm at a school. He then fought with a police officer who was trying to quell the situation, calm it down. The behavior he engaged in is certainly stalking behavior. And that continued even after. He gets arrested. He's been told by 2 courts, 2 judges, not to have any contact with the victim, and that didn't matter to him. And it doesn't matter whether he threatened the victim or not. He was specifically told not to do something by 2 separate judges, and he went ahead and did it anyway. He continued to do it repeatedly for almost a month. So to say that he'll comply with any conditions that the court imposes, you can put him on house arrest, you can put him on GPS, that'll protect everybody. That doesn't keep him locked up. That doesn't keep him out of the community. It doesn't prevent him from going over to either victim's place. In this particular case, he continued violating the law after he was arrested. The court finds his behavior is unpredictable. It's a danger to the community, the school community. While this may not have been a school shooting in the sense and the way that word is used these days, you tell that to the staff and students and faculty at Riverview Elementary School and how they will react and feel knowing that the defendant is out. There's serious psychological harm that will be caused as well, and that's can be considered by the court in determining serious physical harm or risk of serious physical harm. So the court finds that the state has established by clear and convincing evidence that the defendant poses a substantial risk of serious physical harm to any person, that being the 2 victims, John and Lisa, and to the community, and that there are no release conditions that will reasonably assure safety to those individuals and to the community. And the court hereby then grants the state's motion to deny bail in this case. We have a trial scheduled, I believe it's end of April. I don't know the specific date off the top of my head. April 25th standing out in my mind, but I could be wrong on that, but it's in April. The case has been consolidated with the other case. Both cases, indictments will be tried together. Is there anything else we need to discuss at this point?
No, Your Honor, thank you.
Ms. Smith?
No, Your Honor.